Justices of the Appellate Division, 4th Department, hear ye, hear ye, hear ye. All persons having business to do before this court shall draw near, give their attendance, and it shall be heard.
Thank you. Please be seated. Good morning. We have a rather long docket this morning. 17 cases scheduled for argument, 4 with 3 or more lawyers. And if everyone takes the time that they've been allotted, for all the lawyers, we'll be here for 7 hours and 40 minutes. Now, I say that not to discourage you from arguing. I don't say that to get you to rush through your arguments. Merely say it to advise you that if you're later on the docket, you can may wish to go to the attorney's lounge. The library's down there. You need not feel compelled to sit here for all that time watching other people argue unless you wish to. With that being said, the first case for argument is 19 People versus Tyler Felix. Mr. Keene is with us online. Ms. Williams as well. Mr. Keene.
Good morning. May it please the court. Brad Keene and I represent Mr. Felix. I'd like to just focus on the waiver of the right to appeal here. This waiver form is flawed. The form states it's a waiver of appeal and post-conviction challenges. It was never corrected in the oral colloquy. Obviously, I'm very familiar with People v. Hopkins, where this waiver was found to be valid with that particular oral colloquy. But I'd like to really emphasize that this court called that form misleading on November 17th, 2023, and yet the district attorney's office uses that same misleading form on May 23rd, 2024. This court, I just don't think that can be countenanced by this court. There's a consideration issue that I talk about. There's a couple differences with the model colloquy. So I would ask the court to find the waiver invalid and to review the sentence in this issue, or in this case. Unless there's any questions, I'll rely on the brief.
Thank you. Ms. Porter, good morning to you.
Good morning, Your Honors. Keelan Porter on behalf of the people. Calling this a waiver of appeal form has been green lighted by this court, by the Court of Appeals before.
Counsel, so when we do say something like, it's misleading or somewhat misleading, why, he has a point. Why don't you fix that? We've given you the signal. We, sort of ask you to change that, make it more, we've given you the direction, how to make it better. Why don't you do it? Will you take it back at least and talk to people there about making your written waiver a little less objectionable?
The contention that the defendant is making is that just the heading only, just calling this a waiver of appeal form. There's no contention regarding the substance of the form or that anything to do with the substantive nature was at all misleading. In fact, it's abundantly clear.
Oh, we really do understand it, but I guess, he does have somewhat of a point for down the road. Like if you're still doing this in 2 years, are we going to say, gee, that's really still okay? So I guess I'm asking you to take back a message, regardless of what we do on this case, that if we give you that hint that you take it and change things or suggest that things be changed. That's all. You don't have to respond.
But point taken, Justice Bannister. So, but the natural response then, though, that I would give is that it is a waiver of appeal. There are certain issues that a defendant cannot waive, but they are waiving their right to appeal most claims of error. To call it something else, I could also then see us coming back here 2 years from now. We've adopted a different waiver form, and now a defendant is saying that it minimized the ramifications of a waiver and that they didn't fully appreciate it, and therefore their plea was involuntary. And there's sort of a slippery slope there, but I would say that there's still merit to calling it a waiver of appeal form because that is what the defendant is doing. They are waiving the right to appeal.
Aren't we supposed to look at the totality of the circumstances anyway?
Very much so. And there's absolutely no contention here that the substance of the form itself was at all unclear. It made abundantly clear that the defendant was waiving most claims of error, that those were separate and distinct from his other rights that were forfeited by pleading guilty. So the fact that it's just called a waiver of appeal form I mean, if the court would say that they would rather have it titled something differently, I mean, the Thomas Court did say that this might be more appropriately called a narrowing of issues for appellate review, but still said that, you know, just using the phrase waiver of appeal is not in itself problematic. But unless
I would just say, I mean, I don't personally, I don't care. I don't have a position on what I would rather you do. It's not my position to say, to advise you as to what you should or should not do. It's just our position to vote on whether what you've done is consistent with the law. This is a little close. We understand you weren't in the office when this was drafted, so, but I think that Justice Bannister's words are well pleaded, that there's some concern with this one. You may want to,
certainly take that.
you don't want to have to go through this next time.
Right. No, and we'll certainly look at the heading on the form, but just in terms of its substantive nature, we'll say that it's abundantly clear under the totality of the circumstances. And unless the court has any additional questions, we'll rest on our papers.
Thank you.
Thank you.
Case number 20 is People versus Jermaine Dixon. Good morning.
Morning, Your Honor. Stephanie Stair for Mr. Dixon. Excuse me. First and foremost, the waiver of appeal here is invalid. The oral colloquy was one that we've become all too familiar with from Judge Renzi, where he tells Mr. Dixon that when he walks out the door, that's the end of this case, and the appellate division isn't going to review any legal issues. He did mention some that survive, but he generalized them by saying constitutional issues, jurisdictional issues, and the validity of the plea. And then later adds, actually, there's a couple besides the ones I listed, but doesn't actually specify what they are. The written waiver was never discussed beyond being instructed to sign it. And under the totality of the circumstances, I don't believe this was a knowing, voluntary, and intelligent waiver in that it was incomplete, confusing, and at points incorrect.
In watching the video of the interrogation, I mean, there are points where the defendant says, well, I'm not going to talk about that, or makes reference to, I'd like to talk to an attorney before talking about that. And the defendant kind of went back and forth. And I know that one of the arguments is that it should have been stopped before it was. But the question I have is, I suppose, more of a harmless error type of question. It seemed that he was relatively consistent in terms of saying, I will talk about this one thing. And the one thing that he kept saying is that, you know, anything in the house this was found that was illegal, that was mine and not Stacy's.
Right.
And so the question is there anything that he revealed later on that was significantly different? It may be significantly, take out significant, different at all compared to what he said in the very beginning.
Yes, absolutely, Justice. So point 2 and 3 kind of go together. There's the coercion, then there's also the Miranda. What he does admit in terms of basically protecting Stacy is a product of that coercion. They're threatening that they're going to charge her if he doesn't take responsibility for them. In terms of, you know, anything after the 9:35:25 mark, when he says, I want to talk to a lawyer first, the deputy in this, I sort of wrote out a timeline, but every time he gives a little bit more information, the deputy tells him that's not enough, and he presses him for more, to the point where at the end he's actually saying, you know, I'm going to need you to actually describe the bags that these narcotics were in, because it wasn't enough for him that he had said, yes, they're mine. No, it's not hers. 6 times he asks him for more information. So it's not just that he's getting the incriminating information. He wants more and more and more to make his case that much easier, when at the very beginning he said, I don't want to talk to you.
Oh, well, understood. I mean, first of all, the 9:35:25, you know, I'd like to talk to an attorney about that. That was the knapsack, the gun in the knapsack on the porch. That was, in my view, a little bit different. It doesn't appear that he ever discussed that. In terms of saying, you know, the detective trying to dig for more and more and more and more, my question is, did the defendant reveal anything more?
I would have to defer to the record. Off the top of my head, I don't know if he
My
really.
recollection is he did give a lot more details about what pills were there and how they were packaged.
Right.
I think the question, I know Mr. McCarthy argued in his brief, is that before any of the alleged coercion, bringing up Stacy, and it wasn't, we're going to prosecute her, but it was more gentle than that. Before any of that, he took ownership. He said, anything that's illegal inside the house I will own that. And so that cat's out of the bag. That's admissible. And then if he was coerced into giving some more admissions along that same vein, well, he's already said that voluntarily. Justice Nowak wants to know, and I think the answer is yes, that he did go into far more detail later.
Yes, I believe he did. I can't off the top of my head say what details were given at
So
what
it
point.
could be, if we accept your argument, it could be that some of his earlier admissions, incriminating statements are admissible. As we go on, things become inadmissible.
Well, strictly under Miranda, my point is anything after 9:35:25. But under coercion, I would argue, I would respectfully disagree with you, Justice Lindley, that the original taking ownership of it was voluntary, because that was in response to the question, is there a reason that somebody else would be responsible for that?
Right.
He knows that his girlfriend was in the room when the search warrant was admitted. So I think that's,
Right.
it's
He
not
didn't
as
mention-
blatant as the rest
He
of the
didn't
coercion.
mention Stacy at that point. He
Not
just
saying.
said, yeah, he just said, is there any reason anyone else? Because it wasn't Stacy's bedroom
Right,
that she shared with the defendant.
right.
And that is where you say it becomes coercive.
Right.
And it definitely becomes coercive a little bit later on, or
Absolutely.
far later on, and just a question of where that line is. I was concerned a bit about the right to remain silent. He's asked about the stuff on the porch. We have drugs on the porch that he put in the knapsack with LaShonda, dropped them off, and then we got the drugs in the house. There was the gun on the porch.
Right.
He says he doesn't want to talk about anything on the porch right out of the gate.
Yep.
No. That's not the last question about the porch.
Right.
You keep coming back to the porch. Then he says later with the drugs in the room, he's asked, do you want to talk about that? And he says, no, thanks.
Right.
We keep hearing questions about the drugs in the room. So you've got your coercion argument, and then you got the right to remain silent. Didn't seem to be scrupulously honored, is your view.
Correct. And the deputy kind of goes back and forth between the porch and the drugs found in the room. He kind of flip-flops back and forth, and yes, he right off the bat says he doesn't want to talk about the porch. He says no thanks about discussing the drugs in the bedroom. He also says, I don't want to answer that type of question with regard to the drugs. And I would the court seems to have a good grasp on my argument, so I'm not going to belabor them. I just want to point out that the lower court's written decision denying suppression claimed that Mr. Dixon didn't request an attorney until the 30-minute mark, and that's just plain wrong. He obviously said, I want to talk to an attorney right at that 9:35. And he also claims that no promises were ever made that Stacy wouldn't be charged. That's also incorrect. If you look at 9:47:25, the deputy says, in asking Mr. Dixon to describe the narcotics, I need to justify to my boss why we do or do not charge Stacy. So he's flat out saying we might charge her. So I just wanted to point out those two differences between the court's ruling, written ruling, and the actual record. In terms of harmless error, I know Justice Nowak, you said something about that earlier. I think there's a reasonable, under Bowen and Crimmins, there's a reasonable probability here that those statements being admissible at trial obviously contributed to his decision to plead guilty, and therefore it was not harmless. These aren't just kind of throwaway statements. It's literally him repeatedly saying, these drugs are mine, these drugs are mine, these drugs are mine.
We know from the Court of Appeals recently that harmless error almost never applies to a plea. Almost never.
Right.
So I think we understand your argument. Thank you.
I wish just very briefly, on point 4, we're just asking that the court consider reducing Mr. Dixon's sentence down to his minimum of 5 + 5, given the disproportionate sentence compared to his other co-defendants, as well as his original charges. And I would point you to Mr. McCarthy's helpful chart that he included. And if there are no other questions, I would rest on my brief.
Thank you.
Thank you.
Good morning. Marty McCarthy for the people. We've had this argument over the written versus oral colloquy with Judge Renzi several times. I don't, unless there are any other questions about it, I don't want to belabor that. I want to get to what you seem to be more interested in, which is the suppression questions. The defendant's sort of qualifying, or the defendant's using the defendant's statement at 9:35 that he wanted to speak to a lawyer before he talked about something like that. That's not an unequivocal request for counsel, so that all sort of questioning has to cease.
Or like flowers.
More like flowers, yes. So
Was he invoking his right to counsel with respect to the drugs, the bag on the porch?
I would say that's a closer call.
Yeah.
I'm not.
That's the way
Yeah, I'm not.
It's like, I don't want to talk about that without a lawyer. We can talk about the drugs inside.
I'm not going to stand here and say that without a doubt, in terms of a line where that falls on the line, I would say that falls closer to the line of whether that's actually an invocation of his right to counsel. To me, it sounds more equivocal than unequivocal. But that being said, regardless of whether that would be an invocation of the right to counsel for anything found on the porch, that doesn't include the totality of the interrogation. That would only be sort of a limited invocation of the right to counsel.
Did he make any incriminating statements about the backpack?
Not that I recall. I believe the only incriminating statements he makes are about the drugs in the house. So if I'm wrong, again, I'll defer to the record.
The right to remain silent, where he says no thanks when asked to talk about the drugs in the bedroom. This then goes on to answer questions, but
this court, what was the name of that case? You just decided it in November, I believe. That was a lot more unequivocal in terms of that. It was a female defendant whose name I can't recall. It was my office, so I should actually know this. That defendant, she'd repeated it. She was very unequivocal about not wanting to speak. And it was the repetition that the court found was compelling in terms of finding whether she actually invoked her right to silence.
The people be victim.
Yes, that's it. It was the manslaughter case. That was repeated. So like there was a repeated assertion of not wanting to talk about that subject. Whereas here, the no thanks to me doesn't rise to that level in Lipton. And with respect to what the defense is calling coercion, I think I addressed it very succinctly in my brief. What's clear from the interrogation was that the defendant wasn't falsely incriminating himself. That's why we get to those questions about the packaging. Because if the defendant said, oh, well, they were in a purple bag with a goat head on them, and they were actually not at all, then he might have been falsely incriminating himself, in which case then it would be clearer from the record in that scenario that any discussion about Stacy caused him to falsely incriminate himself. Here, these are not coercive statements. The defendant or the police officer didn't come out and say, the only way we're not going to charge Stacy is if you tell me they're yours and not hers. And the statements he made were corroborated by the fact that the details that he provided, they were specific details, as Justice Lundy pointed out, matched what they found. So if there are no other questions.
thank you.
Thank you.
Case number 21 is People versus Martin. Mr. Osler, good morning. We're waiting
for Mr. Keem.
Opposing counsel, who is with us.
Your Honors, this indictment should be reinstated here. The court's decision, although the actual findings of fact and conclusions of law were quite limited. I think it was sort of one short paragraph, couple sentences really. I think reading that, it suggests that the court engaged in really a weighing analysis of the people's evidence in front of the grand jury, which is not permitted at this stage. As I went into in detail for several pages, the police created a timeline. It was explained to the grand jury, tracking the defendant, tracking his associates. We can see what happened during the shooting in question. And we know, I would say pretty much without a doubt, that the defendant was on scene in the vehicle from which shots were fired. There was a casing collected in the car. And we know that there was some measure, I say no, there's certainly a ready inference that there was at least some measure of cooperation, premeditation, planning to some degree immediately prior.
The difficult issues that you have to get over is in shared intent. The victim, Mr. Williams, was shot. He was a member of the 110 Street Gang in Syracuse. He was shot by a fellow member of the 110 Street Gang, Mr. Day, one of his cohorts.
Yes.
Unintentionally, I assume. This is a firefight,
Right.
if you will. The defendant here, the allegations are that he fired shots at them, and that then precipitated return fire where a member of the opposite gang killed a fellow member of the opposite gang. And the defense would argue, how could, to be an accomplice as an accessory, you have to have a shared purpose and intent, right?
Yes, yes.
They say you have members of opposite gangs. It's not, there's no reasonable view of the evidence that they were in cahoots, that they shared this intent at all. Matter of fact, Mr. Day probably didn't even intend to shoot Mr. Williams.
Presumably, yes.
So what's your response to the lack of evidence on shared intent?
So I want to distinguish, before I answer that question directly, I want to just point out that I don't see the court's decision as addressing that issue. I believe the court's decision was purely that there was a lack of, sort of what I term sort of the normal evidence of shared intent, i.e., there's a host of cases that this court and the other department have seen where we talk about, is the getaway driver an accomplice to murder, or just, sort of on scene, maybe charged with something less severe. That's what I think the court's decision was getting at. And to that end, I think we've provided evidence of what I would say is premeditation and tracking their movements right beforehand. But to answer your question directly, in terms of, what I think I would sort of agree is maybe transferred intent, the instigation of that gunfight and somebody being killed in the course of that, I don't see that as meaningfully different than, firing into a crowd and sort of killing accidentally, or, it's not your intended target.
So counsel, though, that's the issue, is what inferences you can draw from that evidence is before the grand jury. And is there even any evidence that he was, we suspect he was involved in this incident because he ends up in the hospital later. That's the best evidence that he was engaged.
Yes.
Earlier. But whether he fired a shot or not, you have to draw that inference from the fact that he was close to the scene.
Close to the scene, and what I would say is you have these three different vehicles that they've been tracking, before and after, and I think there's an inescapable fact in there, and that's that there's the one particular address where the defendant's his mother's vehicle, the defendant's vehicle is seen going to essentially this one particular area, parking lot. The Subaru that is involved in the shooting leaves from that area, returns to that area 2 minutes after the shooting, and then from that spot, he's transported in the Impala to the hospital. And then coupling that, of course, with the fact that these are known associates, they're familiar with each other, and you have the defendant following the Subaru in his own vehicle for a chunk of time. I'm not going to quote an exact amount, but in that previous hour, the hour leading up to the shooting itself. From that, we can see, I would say, an inference, or it's a reasonable inference, that there's a community of purpose. Unlike, I'm going to go back to the sort of the getaway driver scenario, where we can't necessarily point to anything that would say the driver knows what was going to go on and he wanted to take part and assist. Our accomplice standard. There's, in my mind, no real question, or at least there's not a particularly credible attack on the inference that the three individuals in the car knew exactly what was going on. They cased the neighborhood. This wasn't a happenstance incident where defendant happened to be in the back seat. This was planned. And I think this is the problem I have with the dismissal, is that to get around that, we have to engage in a weight of the evidence analysis.
You're saying
is inappropriate.
You're saying there's community of purpose between the defendant and members of his own gang,
Yes,
Bricktown gang.
yes.
Does there not have to be a community purpose between the defendant and a member of a rival gang who shot the victim to death?
Well, I guess I don't necessarily know the answer to that, but to the extent that the court might say yes, I think the fact that the individuals all engaged in a mutual gun battle, that is your shared intent essentially. Even if we take away from the facts of the rival gang membership, you have a willing gun battle at that point in time, and I think it's perfectly.
You have an argument that the first shots were fired out of the crosstrek. So if you can place the defendant in the crosstrek, and the theory as to how to do that is, again, starting with Justice Del Conte's point, well, he showed up at the hospital with a gunshot wound. We know that there were gunshots fired into the crosstrek when it was found. When it was discovered, it had the bullet holes in it. That's sort of the piecing it together. And that's really the argument, is that he was in that vehicle. He doesn't have to be the shooter.
I don't think in this instance he does actually. He may not. I can't point to the evidence and say I know he had a gun. We don't have a gun. He may not actually have held a gun, but the community of purpose is nonetheless there based on what we know he and the others did immediately prior. And on that note, also I think it's somewhat unreasonable to think or take this evidence and view it as just purely coincidental that if you're the driver, and let's say it was just the front seat passenger that was wielding a gun from the Subaru, to think that you plan a drive-by shooting and then add a backseat passenger. I mean, you wouldn't do that. I think the reasonable inference is that the three of them knew exactly what they were doing. They went to the street in question to commit the drive-by shooting, and the defendant knew and was involved in the community of purpose, the intent that I think all three of them share.
Explanation for the lack of blood in the front seat of the Subaru where the defendant was allegedly shot in the buttocks.
So my view of the evidence is he was in the back seat because the shot that entered the rear wheel well went through some of the plastic.
Was there blood in the back seat?
No, there's no blood on the seat. So
he shot in the buttock in a car and he's taken immediately to the hospital. Mm-hmm. Did somebody clean it up, or did he just not start because he was bleeding when he got there?
Yes, I don't know. I suppose it's possible somebody cleaned it up. What I suspect, if I had to speculate to some extent, he was struck in the buttock. It's not an area of the body that would necessarily have a mass blood loss from a bullet wound. There's a lot of fatty tissue. There is certainly some musculature. If you look at his clothing that was collected at the hospital, it's not. There's blood staining. It's not saturated by any means. And since he was only in the car for, again, 2 minutes after he would have been struck, I think it's not unreasonable to think that there may not have been significant blood loss in the car. There may not have been significant blood loss in the Impala that brought him to the hospital either. But I don't think that is a fact that it has significant inroads into the evidence and the inferences that I think can be drawn from them.
You're seeking restatement of the criminal possession of a weapon charge too?
I think both of them would. I think they go hand in hand.
Yeah, well, one seems stronger than the other. The community of purpose on the weapon seems a lot stronger than the community purpose on the murder, which requires a member of another gang. The weapon doesn't need that. That
may be. I personally would disagree, but I'll take your point, Your Honor, and I would still say the underlying problem then is that I don't see the decision order dismissing this as addressing that issue. In that regards, it's not a holding that I need to defend in that way. I just see this as, I read the decision as sort of a pure intent analysis.
Okay. All right. Well, thank you very much.
Thank you.
Mr. Keene.
May it please the court, Brad Keem again. I would disagree with Mr. Osler. Page 90 of the record, the judge finds that there's no mental culpability. I think it's readily inferable that she was talking about the transferred intent. he can't have the same intent as a rival gang member as Justice, I think it was Nowak or Del Conte was saying. It is nice to be respondent and have some of the panel make the points before you get to go. But mere presence, his presence at the scene isn't enough to establish his liability either. It's one of those cases where when the people are presenting the evidence, they still have a burden. It's a prima facie burden, and we would assert that they just didn't meet it here.
All right, thank you. Case number 22, People versus Williams. Case 22. Morning.
Good morning, Your Honors. Jane Yoon for Mr. Williams. When the court is requiring a waiver of appeal on a plea to the indictment, there must be a reason for it in the record. And that reason is not evident in this record. I know this court has previously declined to adopt the Sutton rule in the Second Department. That's a very specific rule saying the court must articulate it. But I think this court still has gone in these cases to look to see what is the reason for the court's waiver, particularly when we're talking about a plea to the indictment.
But doesn't the court give a reason here? I mean, doesn't the court say, I'm going to promise to give you this sentence, provided you waive your right to appeal? Is that what the court says?
I would say the court does not specifically say that on the record here. There's actually some confusion the very first time the court discusses the waiver. The court simply states, there's been a resolution here. I understand.
If I could, let's just go back to your first point here on Sutton, though. That case arose out of a circumstance where the court introduced the waiver after the plea was negotiated.
That was one of the reasons, yes, Your Honor.
Right. This is different in the sense that the court at the outset presents the offer, and it's a reduced sentence with a waiver.
I would agree that the timing of the discussion of the waiver is probably less similar than what the court found problematic in Sutton. And I think with Sutton, the Second Department there had found the waiver invalid for two reasons. One, because the court didn't articulate a reason, and two, because of the timing of when the waiver was discussed. And I agree here that the timing of the waiver was discussed prior to Mr. Williams entering his plea. I would disagree that the reason the court gave for the waiver is clear. I don't think that is clear here.
But it seemed to me in Sutton, the reason for that rule, at least in that case, was to make sure that trial judges, are not introducing waivers before taking a plea to try to protect themselves from judicial review. That's what the Sutton court was most concerned about.
I think the Sutton court is also concerned about why the court is requesting it, particularly when the people are not making the offer. I know that the Third Department has declined to apply Sutton in the cases where the offer comes from the people and then the court later comes in and says, well, I'm requiring an appeal waiver, and the Third Department says that's different. But we're talking about a plea to the indictment, and I would disagree that Mr. Williams got any benefit or that this was really a sentence reduction. I think certainly on paper, it sounds like a reduction, but in actuality, this is not a reduction. This was a plea to murder in the second degree where your sentence range is 15 to life to 25 to life. The court offered a 20 to life versus 25 to life.
He got consecutive for the weapons.
I don't believe he could have, Your Honor. Under the facts and circumstances of this case, I think this is more along the lines of cases where this would have very likely been mandatory concurrent after trial.
What's the issue on that?
Didn't he knowingly possess the firearm before he formed the intent for the shooting? I mean, the shooting happened when the victim pulled up beside him, got out of the car, came around, and that's when he stopped. He's on the bike. I mean, how?
Well, I would disagree that that's how the plea came up. In addition, I would refer the court to the district attorney's response to the bill of particulars, because I believe defense counsel did identify that issue from the outset when she made her omnibus motion and requested a bill of particulars, because the indictment only says that the charges in the indictment occurred at like 8:20 p.m. on the date in question. I don't recall specifically the date. And then defense counsel asked to clarify that in a demand for a bill of particulars. And on the motion argument, well, I first look at the motion response. The written response just identifies the events as occurring at one time. on that date. And then the district attorney does confirm that during the motion argument, saying, yes, we're not talking about, you know, a long period of time when this
Right, but
occurred.
the murder took place outside.
Yes,
Your client had a loaded firearm on him when
I
he
believe
was
that's
outside,
correct.
before any disputes with the victim.
I think that might be
And
correct, Your Honor.
So as soon as he leaves the house with a loaded weapon, he doesn't have a permit, that's CPW, as soon as he steps outside.
That wasn't the people's theory, however.
Right, but just, all right, so the theory would, the only way it's not is if that gun, somebody just immediately or concurrently with him shooting, somebody just put it in his hand. But he didn't possess it at all before shooting, but either way, your point on the waiver is if it's instigated by the judge here, there's got to be a really good reason for it to be enforceable when it's not requested by the people. It's an issue we see a lot. The Court of Appeals is looking at the enforceability of these. We know there's at least 2 votes already to do away with waivers altogether under any circumstances to reverse Seaberg. So we'll take a look at this like we have on the other Sutton cases. On the merits, he got 20 years. We can argue what the cap would have been, but you think 15 is more appropriate given your client was age 17. He was 4'10" and weighed 100 pounds.
Right.
No prior charges. You feel 15 is more in line with a sense of justice.
I think particularly because we're talking about a life sentence here. So 15 doesn't mean that he gets out at 15. 15 means that's when he gets to apply to be released parole. So when he's 17, when this occurs, 20 years, 25 years, I mean, at least give him the opportunity at 15 years to make his case to the parole board to say that, you know, and I think he has shown some of that too during the pendency of this case. It was shown that Mr. Williams, who struggled in school prior to be taken in on these charges, worked with I think it's the Rochester Youth Justice Center, worked with them, improved his grades, was able to get his diploma even before the proceedings concluded. And I think he was looked up to as a mentor within this, you know, the community there, just, you know, so that he's talking about the mistakes that he's made and trying to make an impact. So I think that is certainly some indication of what may be coming. You know, I think the court is familiar with all the science regarding the brain. You know, he's 17 years old. So I think there is a huge difference between just the opportunity to be heard at 15 years versus waiting 20, 25 years, because by then he's middle age. And, you know, I think there is a difference between being 35 and being 40 and being able to apply.
Right now, he'd be eligible for parole at 37.
I think so. Yes, that would be correct.
37 years old.
Sorry?
37, he's eligible to get released. Maybe he gets held for 2 years. He's getting out. The other side looks at it as that's a life sentence for the victim who was 23 years old, didn't do anything wrong, and it's a life sentence for him and his family.
Right.
That's the way they look at it.
Yeah, I understand that, Your Honor. But before we conclude, I would like to go back to why we need to really look at these cases when the courts impose the waiver. I understand the court has my initial argument, but I would also say that the waiver of appeal here was unconscionable at the time it was obtained. And this is because we're talking about the disparity between the court and I mean, he was 19 at the time he took the plea, but he was 17 at the time the incident occurred. He's, you know, has some documented educational issues, as was reported in the PSI. He has no prior criminal records. So in the initial instance, you have a disparity in the bargaining power between the court and Mr. Williams. And then substantively, I think for the reasons we've just discussed here, he really got no benefit from it. This is not a good deal. He really didn't get anything he couldn't get after trial. We don't know there's nothing that he could have, there's no new facts that would have come out after trial that weren't, you know, explored during the motion arguments and the suppression hearings. So I think that's another reason that the court can find the waiver invalid here and then reach the sentencing argument. Of course, this court could also reach into its interest of justice jurisdiction to review the sentence. And I think that would be appropriate here. That's correct, John.
All right, thank you.
Thank you.
Good morning. May I please the court? Christina Harper for the people. Defendant's claims of ineffective assistance of counsel and the severity of the sentence are precluded by a valid waiver. As I argued in my brief, this case is similar to Figueroa and Gaines that were decided recently by this court, and therefore the result should be the same. Should the court reach the ultimate issues, I would argue that The defendant did receive meaningful representation, and the sentence that was negotiated was also fair.
What was the max in your view he could have faced here? Was the consecutive sentencing a possibility here for the weapons?
There was, Your Honor.
What was that?
Because the people do have video evidence, which I assume would have been introduced at trial, where it shows the defendant essentially riding his bike throughout the city of Rochester. He then reaches the neighborhood where the shooting ultimately occurs. He stands there outside with other individuals for about 15 minutes. So during that period of time, at the very least, we do have possession of a loaded weapon outside of his home or place of business.
This was before any intent to use the weapon unlawfully.
Correct.
arose.
So the question would be when he formed the intent to use it. And
I don't think counsel disputes that. She's just saying the way it was charged limits the possibilities on that, but we'll have to take a look at that. But I assume that you believe 20 years is a fair sentence for the murder here, notwithstanding his age.
And we ask that the court affirm the decision. If there are no other questions, I will rest in my brief.
Thank you.
Thank you.
Case 24 is People versus Tyler Felix. Same defendant, different case as our first case that we called. Appellant's counsel's virtual. We'll go in a moment. He's going to be on the screen, yeah. All right. Mr. Benazak, you may proceed.
Thank you, Judge. Good morning, Your Honors, and may it please the court, Peter Banishak for Mr. Felix. I'd like to touch on the first 2 points in the brief, starting with point 1. We acknowledge that while defense counsel challenged the validity of the certificates of compliance, the motion that was filed did not technically contain the requisite allegations with respect to a CPL 3030 statutory speedy trial motion. I would note that counsel did reserve the right under CPL 255.20 to file additional motions depending on the court's resolution of the motion with regard to the certificate of compliance. So in that respect, had the court correctly found that the COCs were invalid, then defense counsel would have been in a position to take the next step and file a motion or make arguments regarding CPL.
So it's the court's fault that you didn't set forth what you needed to do to set out. It's your burden to do that. So you're somehow blaming the court for that, for you not doing that.
Judge, respectfully, I'm not blaming the court. I think I acknowledge that counsel's approach here was not the traditional approach in the sense that I think normally one would challenge both the COCs and take the next step of arguing that the people did not announce ready within the requisite time period. However, those are technically 2 separate motions. One is made under 245.50, the other is made under CPL 3030 and under CPL 255.20, where one motion would serve as the basis to making a further motion. Those 2 motions don't necessarily have to be made at the same time. So in that respect, if this court were to find that the court erred in finding that the COCs were valid, I would respectfully submit that it could remit the matter for further legal arguments to be made with respect to CPL 3030. We also make alternative arguments about why this court should, or that this court should review the 3030 issue in the interest of justice, or find that defense counsel was ineffective for failing to make the relatively basic allegations regarding the commencement date and the people's failure to announce ready within 6 months.
Are we sure that if those allegations have been made, the math works out to be a speedy trial violation?
Judge, I think at minimum, there's a colorable claim that the math works out and that the case, as the respondent's brief acknowledges, commenced on March 7th. It appears that the clock ran until approximately August 18th when defense counsel began requesting adjournments and for various reasons, but then the clock would have restarted approximately on January 25th, 2022, and there would have been more than enough time between January and the trial start date in September. And while ineffective assistance of counsel arguments with respect to 3030 motions typically have to be made in the 440 context, I'd submit that this case is unique in that counsel did make the first part of the motion in the sense that she attempted to controvert the COCs. She just didn't make the second part of the motion. And in that respect, this case is similar to People v. Claremont and other cases dealing with suppression issues where the Court of Appeals and also this court have remitted for further legal arguments to be made. And so in this case, I would respectfully submit that if this court deems the COCs invalid, it would be appropriate to remit for further legal arguments with respect
Could
to.
it be the challenge to the COC unaccompanied by allegations for speedy trial? Is there an argument to be made that, all right, we don't get dismissal under 3030, but there should be a sanction under 24580? If the COC was struck, doesn't always mean that it's time barred, that the action is time barred, but if there was a delay in discovery, then there's always a sanction as a possibility. It doesn't seem like you're seeking a sanction here, maybe because there's no prejudice.
And ultimately, I think defense counsel didn't ask for that remedy either. So essentially, a motion was filed to controvert the COC, but it was as pled was sort of a pointless motion in that there was no remedy attached to it. Requested whether it was in the for a discovery sanction or for dismissal. So I don't think there could be any strategic reason for that failure. With respect to the merits of the COCs, I would rest on the brief. Briefly with respect to point 2, the gist of our argument is that the endangering the welfare of a child statute does require that the defendant have knowledge of the presence of a child and the potential for harm to a child. In this case, there was no evidence whatsoever of Mr. Felix's knowledge that the complainant had his child in the car with him. The respondent's brief can simply argue that Mr. Felix was very likely aware that the complainant generally had a child. I think that's several steps removed from he had his child with him on that day in that car at the time of the vehicle collision. So at minimum, I would respectfully submit that the endangering the welfare of a child conviction should be dismissed as not supported by legally sufficient evidence or otherwise against the weight of the evidence.
Thank you, Counselor.
Good morning. Catherine Menacatz for the respondent. I'd like to direct my attention to defendant's motion before the court on the eve of trial. It's filed on September 9th. Trial was to begin September 12th. Defense counsel, the record shows defense counsel did not access the record for a long period of time. The court had asked defense counsel if there was any problem with discovery. It was never indicated anywhere. And then presumably, right before trial, when going through the evidence, as is frequently done, but in this case, fatal to defense counsel's argument, never alerted the people, at least no record provided by defense counsel in support of her motion, which has no evidentiary support. Additionally, defense counsel stated on the record on September 9th that she specifically did not access the records because she didn't want the people to know what she was looking at.
Do you agree with defense counsel regarding this idea that you can challenge this certificate of compliance without a remedy, without seeking a particular remedy, without establishing what you need to for 3030, without asking for a particular sanction? It just seems to me that we're going to be having attorneys filing motions about, all the other attorney. I just want a declaration the other attorney did something that was late, was improper, was something to no end.
And that was frequently done before the law was clarified for the people. There were frequently motions which didn't necessarily make it to the court, which is actually on the record. You could see I first appeared hired by Wayne County to answer all these motions. That was the problem, which has now been rectified mostly by Bay and his progeny. But yes, just litigating these motions over and over and over, to what end? There was nothing requested in terms of, other than, there was a mention that it was over 30/30, I think, in her motion. I was actually the one that answered it, and that's based on my recollection. But I would defer to the record.
Without an analysis of the time.
Correct. Just this therefore should be dismissed. No, and as far as your question about whether there's excludable time, I would argue that there was, to the extent that you would like me to address that issue. There was originally public defender's office assigned, then newly assigned counsel after that. During that period of time, there was adjournments for.
No, we're familiar with the record,
Okay.
just in terms of the burden, that's all.
Okay. Anything else you'd like me to
Did
address?
this take place after the legislature amended the statute to put a burden on the defendant to alert the people to any missing discovery within a certain period of time?
Yes, and that's addressed in my brief.
And was that raised below as a defense by the people? It's like, look, they slept on this until the eve of trial. If they had done their due diligence, they would have alerted us sooner. Hey, you're missing this or that. That doesn't seem to be a basis for any of the rulings here.
I put it in my papers.
But the court didn't deny it.
This again, motion filed on Friday, people's response submitted Sunday, and Monday was trial. The court issued its decision on Monday. People provided as much evidence as they could in that period of time. I requested time to answer the motion on that Friday before trial, and provided as much as I could. But yes, I did.
Rule on the issue and say this motion is untimely. The speedy trial discovery motion is untimely because it should have been brought a lot sooner. We used to see these at the beginning.
Yeah.
People, they lay in the weeds until the trial, the defendants. You can't do that anymore. That seems to be unintentionally or unintentionally what happened here.
Correct. The court did not specifically, just did a blanket denial of the motion. But those, I did argue that in the court below, that, they basically lied in wait in this case. Is there anything else you'd like to get?
I'm sorry.
Sorry.
On the second issue, endangering the welfare of the child, opposing counsel said that there was, no proof to establish that defendant had any idea that the child would be in there or that child would be in the truck. Can you tell us what that proof would be?
The only thing I can think a jury could reasonably infer is that there was a period of time the defendant was behind the victim's truck and then in front of, and the jury could reasonably have inferred that. The defendant,
Reasonably inferred with the tinted windows?
I mean,
that's before us, they're here, isn't it? I mean, there is no direct evidence.
well, I think that was not, that specific issue was not preserved by defense counsel.
At the trial?
Weighted evidence review here is.
Yes.
You have to preserve weighted evidence.
No,
you don't.
So, yeah, I mean, I get maybe you can get an indictment on that, a warrant, beyond a reasonable doubt that he saw this kid. I don't know about beyond a reasonable doubt, but we're going to find out.
Right.
Thank you very
I
much.
defer to the court. Thank you.
Case number 25 is People versus Dennis Jones. Morning, Mr. Duffy.
Good morning. Casey Duffy on behalf of Mr. Jones. The trial court committed a mode of proceedings error in misinterpreting CPL 270.25 subsection 3 when it failed to require unanimous agreement between both defendants.
Pretty much directly violated that statute, right?
If we agree on that, then I can move on to.
Well, I only speak for myself.
Okay.
Yeah, I'm curious, you say mode of proceedings right out of the gate. Well, usually we get to mode of proceedings for issues that are not preserved. This was preserved, was it not?
Well, I'm kind of framing the issue to skip to harm, which seems to be the key point of dispute in the briefing.
But the court ruled on this anyway. The court said for peremptories, you both have to agree, or either one. You don't need both to agree to strike somebody.
Correct.
And that sounds more fair to the defendant. Because nobody the defendant didn't like wasn't going to be on the jury. They were all going to be removed. But on the other hand, as you'll say, there's going to be people on the jury who we didn't want. So that's the other side of that coin. But we understand the statute says that it has to be a majority. A majority of 2 is 2. It's unanimous. We didn't have that. There's case law that establishes that the statute's been changed now. So you seem to have a strong legal footing for the fact that the trial court handled peremptories improperly in violation of the law.
I agree completely. And I think
you might
just one point I'd like to address that the issue of whether Mr. Jones suffered harm as a result of the misapplication of the statute. And one point that wasn't clarified very well in the briefing is that defendants together used all of their peremptory strikes by the time before the entire jury was.
And they didn't agree on how to use them.
Correct.
And they didn't have exactly the same defense strategy. That there was, some conflict between them.
That is correct.
There would be prejudice.
Right.
Aside from the fact that there's 3 prospective jurors, 3 people who were not challenged by your client. Your client had no problem with being on, but they were struck by the co-defendant. So they were not. 3 people your client wanted on who didn't serve on the jury. That's enough prejudice for you.
Well, that is prejudice, but there's the additional prejudice that comes from they used all their peremptory strikes. 3 were used without Mr. Jones's consent, and there were jurors who were ultimately seated, and Mr. Jones had no opportunity to strike me. I think that is obvious.
But it sounds like there may have been jurors that he wanted that were struck too.
That's
the other side of the prejudice coin.
Correct.
Do you want to be heard on the severance? There's a lot here. You have a number of other issues. You've got the subpoenaed records regarding the examiner of the fingerprints. You want to choose 1 or 2 of those to be heard. I'm a little curious on the severance. Your argument is that there were 2 prosecutors in the courtroom against your client during opening and closing arguments. The fellow defense lawyer was pointing the finger at your client.
Correct.
The law seems to be, though, this surprised me, it's not so much what the arguments are, but what the evidence is. Was there any evidence that the co-defendant admitted that was harmful to your client?
I believe he had tried to admit evidence of some prior bad acts on Mr. Jones's part. I don't recall specifically, but the main conflict was just the theory of possession. Mr. Murray pointed to, the fingerprint found on the USB charger box as some indication that Mr. Jones only knew what was inside that box. And there were just, from the start of jury selection, indications that there was their theories of the case were incompatible with one another.
So you can.
But wasn't that harmless error?
I don't believe so. At the time that these rulings were made, it seemed clear that they were going to be pointing the finger at one another, and that severance was appropriate from the outset.
Anything further?
No. Thank you.
Good morning, Your Honor. David Baston for the people. It's our position that there was no error with respect to the peremptory challenges, the way it was treated. I think the fact that the law has been subsequently changed shows that it was ambiguous as written at the time. Therefore, the court had some discretion to interpret it in a way that did not seem to prejudice either defendant, or it was at least as fair as possible.
Was there any case law that existed at the time that supported the court's theory that they both don't have to agree? Was there any?
Not to my knowledge.
Because there was authority on the other side of it.
Under the previous statute, I believe, that preceded 270-25, there was some case law that supported the appellant's interpretation here. But even if, the court did err, it's our position that error was not prejudicial under the circumstances. And this court has said recently in, I think, a similar case, a violation of 270-15 in the sequencing of peremptory challenges was not sufficiently egregious to be prejudicial error. That's People versus Faes, F-A-E-S. And that's quoting, I think, from People versus Caban, the Court of Appeals, that the error must be sufficiently egregious and prejudicial to compromise defendant's right to a fair trial. And here, the defendant was simply in the position that any co-defendant would be in a multi-defendant case where the majority of defendants do something in peremptories that he doesn't like. He's not getting his say, but that's already contemplated by the statute in a multi-defendant case for peremptory challenges. So I think under the circumstances, the error was not sufficiently egregious to compromise his right to a fair trial.
Yeah, I think the Court of Appeals explained it with severance that there's always going to be prejudice in a joint trial. There's always going to be something.
Right.
But we balance that by the benefit of judicial economy and resources, having two separate trials with all the same evidence. So it seems to be contemplated, yeah, it's not going to be as, if there's going to be a little more prejudice to the defendant than it would be if it's a standalone trial.
Yes, this was a case I recently argued in the Court of Appeals versus James Everson. There was some conflict in the summations given by the attorneys, but no conflicting evidence. And the Court of Appeals said in Everson, citing back to their decision in People versus Mabubian, there has to be a irreconcilable conflict in the core of the defenses, and that conflict alone has to be sufficient to find guilt for that co-defendant. And what they said in Everson essentially is that this kind of discord arising on summation, where what the attorneys say is not evidence, is not sufficiently, it's not sufficient to be a conflict, or such a conflict that is unfairly prejudicial to satisfy the two-part Mabubian test. And I think the same thing is here, which the only difference is there's some conflict in the openings as well as the closings. It's still just attorney arguments, which are not evidence, and the jury was instructed as such. And to your point, Justice Bannister, there was no conflicting evidence. The defendant tried to elicit some, I think, from his co-defendant or vice versa, but it didn't actually come out. There was an objection, and the evidence was not elicited, which distinguishes this case from others, where you could say there's conflicting evidence, which I would submit should be the crystal clear rule in these cases, that conflict and prejudice should be measured by evidence. That is the clear rule to guide trial courts and how to resolve these severance decisions. And that didn't happen here. There was no conflicting evidence, just argument.
Thank you, Counselor.
Thank you.
Case 26 is People versus Courtney A. Barber. We have Mr. Lana is virtual. Can you hear me, Mr. Lana?
I can, Your Honor. Thank you.
All right, good morning to you. Opposing counsel is here in the courtroom. You may proceed.
Thank you, Your Honor. May it please the court, Anthony Lana appearing on behalf of Courtney Barber. Your Honors, we are asking for the judgment of conviction to be reversed and a new trial ordered. In this case, it is uncontroverted that the trial court engaged in some form of conduct that required intervention with the jury and precipitated defense counsel to file a motion for a mistrial. The defense counsel has a specific recollection of the trial judge having his arms spread apart, palms open, facing up, and shaking his head while looking at the while looking at the prosecution during the course of the direct examination of a defense witness. This is a clear invitation to the jury that the trial judge disagreed with or had an issue with the testimony of that witness and was inviting the prosecutor to object to the testimony.
Yeah, well, I didn't take it as he necessarily disagreed with the testimony. It sounded like he disagreed with Mr. Schiano's questioning, like maybe the basis for the questioning. Not necessarily he disagreed with the testimony.
Yeah, either way, Judge, it certainly created an impression to the jury that the prosecution needed to do something or was in disagreement either with the line of questioning or with the testimony itself. But either way, it created the impression that the judge was an advocate for the people by gesturing that way to the jury. The judge doesn't have a specific recollection of doing that, but he did indicate that he may have looked up during the course of that testimony. The ADA Gallagher indicated that he doesn't have a specific recollection, but he does admit that the judge did say or do something along the lines of what Mr. Schiano had indicated in his motion. So there's no contention that something did happen. And I know it was addressed with the court and the jury in a curative instruction, but we all know it's very difficult, if not impossible, to unring a bell, to unsee what you've seen, to unhear what you've heard, despite the fact that the court instructs the jury to follow the judge's instructions. Once they've seen or heard something, we have no way of knowing whether consciously or subconsciously that entered into their decision-making process. The only way
we don't, counsel, I'll just jump in for a second. We don't have an objection made to the specific curative charge here. There's a model charge, and the judge added to the model charge to talk specifically about any gesture I may have made, any expression, that type of thing. So there's no objection to that. So the argument therefore must be that no curative charge would be sufficient, that only mistrial is sufficient, and that's only based on defense counsel's allegation of what took place and the court saying, gee, I just looked up. And so the question I have is that if no curative instruction can take place, what would prevent a defense attorney in any trial, if it's not going well, to say, oh, gee, I didn't like the way you turned your head. I didn't know, and now we have to have a mistrial and a do-over.
Well, Judge, I don't know that I can address every potential hypothetical with respect to that, but in this particular case, I think when if it would have been the testimony of, a random witness or of a witness on behalf of the people, or a scene witness or something else, I think it would have a different impact. The fact that this was the direct testimony of a defense witness, and the court taking that position, I agree with you that, there's not going to be a one-size-fits-all rule that applies here, but dealing with this particular set of facts, I believe that the court's conduct here was inappropriate and obviously prejudicial. They're not disputing that the judge engaged in some conduct by any of the parties. They don't have a specific recollection other than with respect to defense counsel, who does have a specific recollection of what conduct the court actually engaged in. And I understand the court's concern with future cases, but when the court or the jury sees or hears something, it's very difficult, if not impossible, to determine whether or not that seeps into their conscious or subconscious thinking, despite an instruction to disregard that on behalf of the court. So the only way, in my opinion, to ensure that is to order a new trial free from any inappropriate conduct and prejudice.
All right. Do you want to briefly discuss some of your other issues?
I do. Thank you, Judge.
Weight of the evidence and so forth?
Yes, thank you. Judge, with respect to the weight of the evidence argument, as the court's aware, in order for there to be a conviction of an attempted crime, the initial crime has to come dangerously close to completion. In this particular case, the testimony from the victim is that the entire incident lasted 1 to 2 minutes, very brief, that there was no DNA in this particular case, that the victim indicated to the same nurse, real close in time to the incident, that she felt something hard against her vagina. Doesn't know if it was a penis, doesn't know if it was a hand, or doesn't know if it was something else. There was no torn clothing, there was no bruising, no DNA. Obviously, nothing recovered from the defendant himself as far as fingernail scrapings or anything along those lines. So to argue that this came dangerously close to the commission of a rape in the first degree, I think is against the weight of the evidence, given all those factors in totality.
Why is the fact that they found the male DNA not sufficient, because it wasn't specifically related to this defendant, or because we did have the testimony, I think, from the victim that she hadn't been with men, I forget what it was, maybe a week. I forget how the question was posed, but why was that insufficient?
Because I believe the testimony was that the DNA could have been from rolling around on the ground together. It wasn't necessarily, there was no bodily secretions or anything, semen or anything along those lines. So that could have been by skin transfer. That could have been by the fact that they were rolling around on the ground together.
Could have been from his hand.
It could have been from his hand. It could have been
Which
from
might not be, but you're not disputing the overwhelming evidence that he stalked this woman on the bridge and then beyond tackled her, wrestled her to the ground, pulled up her skirt. It's just, did he come dangerously close to doing what he intended to do, but was stopped based on the fact that she set off the alarm on her phone and other people came?
Well, no, Judge, the defendant's testimony was that this was not a premeditated stalking attempt to commit a rape.
I've read a lot of testimony in my day. I'm not sure I've read anything more incredible than the story he told at trial and to the police. But that doesn't detract from your argument. Your argument's a different one. Your argument, given the truth of the victim's testimony here, did it come dangerously close? And that's a better argument. You're making better arguments than he made on the stand. I'll say that.
Well, thank you, Judge. So yeah, that is my argument, that it did not come dangerously close to the commission of a rape in the first degree. Therefore, the weight of the evidence would fall against the conviction for attempted rape in the first degree. And lastly, with respect to the harsh excessive sentence, Mr. Barber at the time of conviction was 32 years old. He has one prior felony conviction, non-sex related, for attempted possession of a weapon. He was placed on 5 years of probation, no violations of probation. In fact, he was so compliant that his probation was terminated prior to the expiration of the maximum term of probation. He was gainfully employed. He has a stable family unit in the Rochester area. To impose the maximum sentence given those circumstances, again, as a whole, I believe would be harsh and excessive. He's 32 years old. Between the term of post-release supervision and the term of incarceration, namely the term of 15 years followed by 20 years of post-release supervision, he would be either incarcerated or supervised longer than he's been alive for a first offense of a sexual nature, and with a limited criminal history and a history of compliance with respect to terms of probation. So having said that, I would rest on the brief. Thank you.
Thank you, Mr. Lana. Thank you.
Good morning, Your Honors. May it please the court, Lisa Gray on behalf of the people. Unless the court would like me to address point one first, I just wanted to touch base on the weight of the evidence issue, if that's permissible for the court. Just with respect to the weight of the evidence, the attempted rape conviction was supported by overwhelming evidence in this case. The jury heard compelling evidence from the victim who testified, who described with particularity the events that happened, how the defendant tackled her, how they fell down that hill. He hiked up her dress. He took his pants down. He clenched her face. Was he telling her to shut up because he didn't want her to make it more difficult for him? And the only reason why that rape was not completed was because 3 Good Samaritans heard her scream and interrupted that attack. There's other corroborating evidence that went to support what the victim testified during the trial. There was the evidence of the Good Samaritan, Lashana, I believe her last name was Williams, who testified at trial, describing what she observed that night when she saw the victim walk by her car, the description of the defendant.
I think it's abundantly clear that there was a sexual assault. Mr. Lana's argument is he's charged with rape. The victim here was unsure what came into contact with the genital area. Was it his penis? Was it his hand? Was it elbow? What was it? If it were the hand, does he have a legitimate argument here that that's sexual abuse, but he didn't come dangerously close to rape? How would you respond to that?
Well, I think by the victim's own testimony, of the fact that the defendant had pulled down his pants and was pinning her down, I think the inference from there is that he was going to use his penis in order to penetrate her. So the evidence the evidence fully supports that verdict of attempted rape in the first degree. I don't think there's a question about that. They didn't reach the rape 1 count, and they then went on to address the attempted rape. And the evidence of the account given by the victim does go to support the fact that the defendant took all but the steps of penetration with his penis in order to complete the rape.
I don't recall, you can correct me if I'm wrong, Mr. Shiano's argument in closing at trial was different than the argument Mr. Lana is making now. The defendant testified and said, no, I just bumped into her and we rolled down the hill and I somehow grabbed her phone and walked with it and just threw it in the woods so maybe she'd get it. It wasn't, yeah, I was trying to assault her, but not rape her. That wasn't presented. Mr. Lana's coming up with seems to be a more plausible argument than what was argued below. Does that make a difference here?
I mean, I think it does, sure, because the way it was framed below by Mr. Shiano was that this was just a giant misunderstanding. I bumped into her, rolled down the hill. She's a young white girl. I'm a black man. People aren't going to understand. They're not going to believe me. I mean, so that was the argument made at trial. And obviously, closing arguments are certainly not evidence, but through that lens, the jury is going to evaluate the evidence, the testimony and the corroborating evidence and the forensic evidence, and the conclusion that they came to, that verdict of attempted rape in the first degree, was certainly supported by overwhelming evidence.
About Judge Randall's alleged, the allegation was that he did something with his hands and then he later said maybe looked up.
So
what are we to make of that?
What I think about that is Judge Randall indicated that he doesn't remember making hand gesture. The prosecutor, when asked, says, I honestly don't remember if the court made a hand gesture. The prosecutor said, I do remember at some point the court looked up during the direct examination of one of the defense witnesses. But that doesn't necessarily, because those two players in that moment didn't necessarily have an independent recollection of hand gestures being made, doesn't mean that they actually were made just because Mr. Shiano alleges that those hand gestures were made.
Well, we know from the transcript that Judge Randall clearly thought and a hearsay objection should have been made because there was one made later. He says, well, too late now, so overruled. So there's clearly, I don't know about frustration, but he thought an objection should have been made earlier. So it's not outlandish for Mr. Shiano to be making these claims.
And I think the curative instruction given at the time of the jury instructions completely addressed that. You read the instruction yourself, you know what it says. But Judge Randall said, listen, to the extent I might have made a hand gesture or my tone of voice changed or my inflection changed, you're the finders of fact. You're not to infer anything from any change in tone of voice, certainly to the detriment of the defendant. And the jury is presumed to have followed that instruction. And I think looking at the record as a whole, there's really nothing to indicate other than what was put on the record at the time the mistrial motion was made, that Judge Randall was anything other than a detached and neutral magistrate. And to the extent, again, if there was a change in inflection or tone, curative instruction was given, the jury is presumed to follow it. And just with respect to the sentence, the 15-year max sentence, I believe, is just commensurate with how the evidence in this trial came out. And I think Judge Randall did a really nice job at sentencing, making a record and just explaining where that 15-year sentence came from. I trust that the court has watched the video surveillance that was entered into evidence, and that's really compelling to watch that 17-year-old girl walk over to that footbridge and have the defendant turn around and follow her through lighted areas of that parking garage until he could get her alone in an unlit area and commence an attack. And Judge Randall absolutely hit the nail on the head. When that conviction or when that event happened, not only did it affect that 17-year-old victim, it affected those U of R students, it affected the community. And I would urge this court to affirm this conviction in its entirety. Do not downwardly modify that maximum sentence. It is absolutely warranted on the facts of this case.
Thank you.
Thank you.
Case number 27, People versus McGinnis. Good morning. Mr. Gilman.
May it please the court, Braden Gilman for Jonathan McGinnis. I'll focus primarily on points 2 and 4 of my brief, unless there are other questions. Starting with point 2, the weight of the evidence. This verdict was against the weight of the evidence because at most all that was proven was mere presence. There was no identity ever proven. There was no eyewitness identification in this case, no forensic, no fingerprints. Mr. McGinnis was excluded from the DNA. As far as what was recovered, there was no gun, no mask, no clothing, and no contraband ever
You
recovered.
agree they established beyond all doubt that your client's cell phone and the motor vehicle he used was in close proximity to the murder and the other armed robbery at the exact time. And that the car and cell phone then, the path of that went to the co-defendant's house and then back to your client's house. You would acknowledge that much, right?
I would acknowledge in part, there's so as far as the November 9th robbery, there was evidence from the Google location information that Mr. McGinnis was over a block away on the other side of Ferry Avenue.
Mr. Smough, yeah, I'm talking about the murder and then the 7-Eleven robbery, both in the same night. We had cell phone tracking, we had Google for his email, and we had license plate trackers. The car your client drove went from his house, and then it was in the vicinity of both of those crimes at or about the same exact time. With the co-defendant, who he knew. They tracked it through Facebook. They had been convicted before of a crime. That much is true. I guess you're saying, well, somebody might have had his cell phone, might have been his wife or somebody might have had his cell phone. Somebody might have been driving his car. Problem is, the videos from the two robberies show a man, not a woman, and the person had dreads. Your client had dreads, matched the height, stature. That's not enough for you, though.
The allegation that he had dreads was based on one eyewitness, Joe Sibilia, who was in the 7-Eleven. He stated that for the first time at trial. He had never stated that before the grand jury, nor to any police officer that he viewed the dreads. It was as he was falling back over a stuffed animal display in a short period of, a few seconds, he was alleged to have seen this.
Counselor, can I go back to what Justice Lilly was talking about? I'm going to call it the pinpoint data. Your client's cell phone. You don't dispute that it was indeed his cell phone.
That's correct.
His cell phone with his cell phone number traveled from his house to his nephew's house. And then that cell phone, and then the nephew's cell phone traveled to the first robbery. The storekeeper was killed. Then it traveled to the second robbery, right at the same time that store was robbed. It's captured on video. And then that cell phone also traveled back to your client's house. You don't disagree with that evidence?
That is true. With
somehow that cell phone moved from Buffalo to Niagara Falls and back to Buffalo to your client's residence, and it wasn't your client who was attached to that cell phone moving across those two counties.
That is true, and with that we do dispute in part, and that's
one other piece of evidence.
Oh yeah,
your client, I think, did admit or testified, or there was a stipulation that the Honda Pilot was his, and he was the sole driver.
That is correct.
And that same car that he's the sole driver of made that same track with the cell phone.
Yes, but all that was proven was only circumstantial evidence that there was mere presence, and with regard to the actual location data, for example, with the cell site location information, there was a variance of 2 miles. So at any given time, there was
let's be clear though, the cell site information is a little different than the Google pinpoint information. The Google pinpoint information locks them right down to longitude and latitude. Locks the phone down to longitude and latitude.
On November 21st. If we're talking about on November 21st, outside of the ping that was outside of the bridgeway, that ping was at 7:22 and 23 seconds. The robbery happened at 7:25 approximately, and the surveillance, exterior surveillance camera footage shoots up Memorial and up Niagara. If he were to be at that time at 7:22:23, he would be in the area that's covered by that exterior surveillance. And the direction in which they come from also is they come from the north of Memorial Avenue down and enter in Niagara Street. That is not consistent with the Google location information, which also would have been, there's also variance in that as well, up to 16 meters as 16 to 24 meters, which could be a difference being between being in the stores, either 7-Eleven or the Bridgeway, and out in a car outside of those
Best case
locations.
scenario for your client is he was with the two people who went in and robbed him. He was with them all the way. He just didn't go inside the store.
That is one
Best
possibility.
case scenario for your guy.
Yeah, that's
Worst
one
case is he's the one who went in.
Right. And I'll just move on to point 4, the circumstantial jury charge issue. The evidence that was put before the court here was only circumstantial evidence. The court really relied on this idea that just because there was a video, it constituted direct evidence. That's not consistent with the case law. We really have to look at what the video depicted. Here, standing alone, the video only depicts that there were robberies. There were robberies and shootings on those days by masked men, and that directly from the without any evidence, other evidence, we can't look at the video and without, even the court said, without certainty.
If the videos clearly depicted your client, it's direct evidence. If it's unclear, we need some other inferences, then it's circumstantial.
That's correct.
Is similar to the Exford case a little bit.
That is correct.
Although there wasn't his identity, there were other inferences needed there to establish.
So you're saying the court should have given the full circumstantial evidence charge?
Yes, and that's because this was a case as kind of going as we were discussing before. This is a case that was not harmless error. This was a case that could have went either way. So the court really needed to inform the jury fully of what the inferences that they could have drawn. And when the court cut the circumstantial jury instruction in half, the jury wasn't adequately informed, and this is not a valid verdict accordingly. We'll rest on our brief.
Thank you.
Good morning. May it please the court, Laura Jordan on behalf of the Niagara County District Attorney's Office. First, in regards to the weight of the evidence argument, there was what I would submit was overwhelming evidence in this case. We had the cell phone records as well as the Google records. I tried to convey it in words in my brief, but really the best evidence if the court takes a look at those geotime maps that were made as well as the PowerPoint.
Yeah, we've seen all that. Counsel would say that's just mere presence at or near the store, and that's not enough. You need more than mere presence. What do you have that shows that he was actually inside the store or otherwise participated in his crimes?
We have the surveillance videos from both of those stores. I would submit, obviously, my argument was that those were direct evidence. Those videos are crystal clear. If the court has reviewed them yet or not.
Crystal clear about what?
About what occurred in those stores and what these.
But not who did it.
I would submit that it is.
It is?
I understand that they were masked. However, this defendant had dreadlocks that was shown at the time through the photograph. You can see in the video like a protruding back of his hood. You also had the officer who described him as having dreadlocks as well. The court pointed out when it denied the motion to dismiss that they had the opportunity to view this defendant, as did the jurors. This trial was almost 2.5 weeks. They all have the opportunity to view the defendant.
Right, but the perpetrator was wearing a mask. And this argument, well, we looked at the defendant all day in court every day, and we saw the video of him without a mask. Well, that flies, but I'm not sure you don't need inferences to come to the conclusion that you're coming to is like, it was clearly him. You're already relying on one. Well, he had Brad, the other guy, so there seems to be some inference there, but
Counselor,
go ahead.
I'm sorry. As I understand the evidence, though, it was the overlap between the two cell phones that also drew a lot of the circumstantial. It wasn't just the defendant's cell phone; it was his nephew's cell phone, and that they were acting in concert for all 3 armed robberies.
Correct.
The cell phones moved together, and they knew each other, and they operated together. And his build matched the stockier gentleman, robber, white gloves or black gloves. I can't remember which one. And then his nephew matched the other perpetrator. So when you put all of that together, you get to overwhelming evidence. That's your point.
Correct. And the fact that the co-defendants, they had communications between their cell phones earlier in the day. We have the Easy Pass records that show defendant's vehicle crossing over the Grand Island Bridge. As soon as he gets over the bridge, he sends a text to his nephew. As soon as those two are together, those communications stop for the entirety of the time that they are committing this robbery and the murder. He drops him back off at his apartment, goes back over the Grand Island Bridge. We can see that in the Easy Pass records. And then he doesn't call him again until he's back home in Buffalo. And I think that that's important too, because you do have the cell phone records from both of these individuals, and you watch the path that these two take, and they take that entire path
There's
together.
no, beyond all doubt that they were there at the scenes of the crimes. It's a question of whether there was somebody else. And that's where we get to the tower dump evidence, showed there's only two that matched. But that didn't come in at trial, I don't think.
It did not.
Because that would be pretty incriminating. Like, that would destroy this theory that we were there, but we were with the people who actually went in. But we understand your argument. You want to be heard briefly on the circumstantial evidence issue, whether that's direct or circumstantial.
Judge, I would submit, again, as I argued in my brief, that it is in fact direct evidence. The court pointed out that it was that it believed that the people in the video had the same posture, the same gait, the same bearing as the people that were depicted in the video. Again, I don't think that the court can discount the fact that these jurors had the opportunity to watch this defendant move in the courtroom, perhaps walk up to the bench, had, every day for 2 weeks, an opportunity to observe him and to see whether or not his movement was consistent with the person that was in the video. Again, the jurors could have also rejected that was the person depicted in the videos, but that does not change the evidence from direct to circumstantial.
Thank you.
Thank you.
I'm going to call the case out of order here. We're going to 29 first, 29, Irwin versus Snyder. We're going to save 28 momentarily. Irwin versus Snyder. All the lawyers are virtual. Const, we're waiting for Mr. Pulver now will be the third. Hopefully he's ready to go.
Your Honor, Mr. Pulver is not on the list.
He hasn't signed in?
He checked in, but he is not on the list to bring in.
Okay, we will recall that momentarily. Let us go back then to 28. My apologies. We're going to recall 29. I thought we could dispose of that one sooner than 28. Good afternoon, Mr. Ruddy.
Good morning, Your Honor.
Good morning.
Or we're almost afternoon, but not quite.
Yeah.
May it please the court, Sam Ruddy on behalf of petitioner Jewish Home and Infirmary of Rochester. This case concerns an audit adjustment by the Office of Medicaid Inspector General, or OMIG, where respondents ignored decades of precedent and their own understanding regarding the scope of OMIG's legal authority in order to recoup millions of dollars from petitioner Jewish Home and Infirmary of Rochester. We are here today to respectfully request that this court reverse and annul the administrative law judge determination that upheld OMIG's ultra-vires and arbitrary and capricious audit adjustment, and to order respondents to return the amounts improperly recouped thus far pursuant to the adjustment. Now, for decades, New York's Medicaid system has operated under a clear division of labor. The Department of Health's rate setters at the Bureau of Long-Term Care Reimbursement, which I'll call DOH today, they are the policymakers. They make the judgment calls.
Counselor, let me just, let's, I'm glad you're starting there. Is it your position that OMIG has no role in interpreting the Department of Health regulations?
So they have a role to operate within the judgment calls of DOH.
Right.
The Atlantic Care Management case itself says These regulations, the Medicaid rate setting regulations, are DOH's regulations. And
Right.
OMIG is a
I read
separate
that
entity.
case. That's
Yeah.
why I wanted to bring it up, because that's the case that you really rely on in your reply brief. And the court there said, our review of the determination requires that we defer to OMIG's interpretation of DOH regulations.
Yeah, I understand that, Your Honor.
Right.
And I think it's actually important to look at what the court actually deferred to, which was that OMIG had no authority to make methodological judgment calls. And so therefore, the court reasoned it could not revisit the meaning of the Medicaid rate setting regulations because those necessarily implicated the applicable Medicaid rate setting methodology, which is an issue reserved to DOH, not to OMIG.
Did DOH ever make a contrary determination here?
No, Your Honor. And I think
it's not like DOH said subsection C applies. We're talking about the section 86-2.2 C, which is what you say applies. The department says F applies. DOH, Mr. Simmons, I know there were some conversations. There's no indication he explicitly agreed that C applied.
To the contrary, Your Honor, we have unrebutted testimony from 2 eyewitnesses that said that C applied, but actually we're not only relying on that, we're also relying on the fact that that DOH then subsequently approved multiple years of Medicaid rates following that, including the 2017 Medicaid rates.
With that though, that's where I understand. I think that's your position that DOH adopted a certain view of the 2 separate regulations. But that's always the situation, that they prospectively approve rates subject to audit. I mean, every time that they approve a rate in an interim basis, it's possible that the Office of the Medicaid Inspector General will then potentially reinterpret it or draw a conclusion that the methodology was incorrect.
So I would just disagree with that, Your Honor. And I think there's decades of case law here from this court's decision in Hurlbut v. Wayland through Anthony L. Jordan, which is a decision from the Supreme Court in Rochester, Teresian House, all the way through Atlantic Care Management. That really stands for the fact that what OMIG's role is here is to correct errors of fact. You know, these auditors are auditors, and what they do is they check the underlying books and records to say, okay, was something, whether accidentally or intentionally, misrepresented? Was there something that wasn't disclosed? By contrast, DOH is supposed to make these methodological judgments up front, and the precedents say those judgments are binding on DOH. And I think that's particularly important because, as noted by the Hurlbut decision all the way back in the 70s, the entire purpose of having a prospective rate setting system is so that nursing homes can depend on something. So, you know, you want,
and but that gets to the heart of this case, because the nursing home had the full value of that mortgage cost was baked into the reimbursement rate, the 40-year mortgage original, which was, I think at that time, around $21 million.
Correct.
And so then when the mortgage is forgiven, you don't disagree that some adjustment has to be made to future reimbursement rates. The question is how do you reimburse that? How do you make that adjustment? Is it a single year or a multiple year adjustment?
That's correct, Your Honor.
And your position is DOH somehow had a policy that it should only be readjusted in a single year. And that's based on the Simmons conversation.
It's based on the Simmons conversation.
And the fact that they paid prospectively on those rates.
Well, it's based on the Simmons conversation. It's based on the 2015 cost reports, where the full amount of the mortgage forgiveness was provided to DOH, reported to DOH, and DOH approved that, both with it wasn't just the number, it was a narrative description saying we had this mortgage, it was forgiven, it's $10 million. And then we also have, on top of that, the 2015 rate appeal, where Jewish Home specifically put to the DOH saying, hey, we want to fully account for the effect of our forgiveness on Jewish Home's mortgage in our 2015 rates, which is one of the rate years at issue here. And DOH approved that rate appeal without applying subsection F.
Would you concede this much, that under accounting principles, basic accounting principles, your client's position that this gain, $10.3 million gain when the mortgage was forgiven. Reporting that gain all in 2015 makes no accounting sense as compared to amortizing it over the 9 years. Would you agree with that?
I'm actually not sure I would, Your Honor, not because I, frankly, it's because I don't think there was really any evidence introduced to that point.
How about if I explain it this way? If it's not amortized, this gain, the rates that your client gets reimbursed for Medicaid are based on the costs that your client incurs, right? Less money that comes in. This was money that came in. This was a windfall, based because the bonds got paid off before the mortgage. So there was a mortgage forgiven of $10.3 million, $10.5 million, right? So the way that the department looks at it is that if that's not amortized over 9 years for the remainder of the mortgage, your rates are going to be based on costs that they did not incur.
I don't think that's fully right, Your Honor, because, for example, in the 2015 rate appeal, we filed an appeal to remove the mortgage interest expenses from our nursing home rate. So, and then if you look at the cost reports in future years, those expenses aren't reported. So, the additional costs that would have been there were no longer there. And Jewish Home filed an appeal specifically to address that in the 2015 rates, and that appeal was approved. And, and DOH continued to have these opportunities to make these judgment calls again and again in 2017, 2018, 2019, 2020, and in subsequent years, and they never changed their mind. So really the opportunity for that would have been in any of those rate setting proceedings, in the rate appeal, but that didn't happen. And
we're going to have to agree to disagree on whether it's proper accounting to do it under C as the F. I am not persuaded that C is proper, but this really distills to what is the definition of a public finance authority under F. Is this East Rochester Housing Authority that floated the bonds, is that a public finance authority? The term public finance authority is not defined in these regulations. We're not talking about a statute. We're talking about a regulation drafted by DOH. Are we not supposed to give some deference to their interpretations of their own regulations?
And we are asking for deference to DOH's interpretations. We're just asking for deference to the rate setters who have the authority to make these interpretations that are then binding on OMIG. So, I think it's actually particularly striking here. Jewish Home is the entity, the party in this case, that's asking for deference to the subject matter policymaker experts here that exercise their judgment in formal rate setting proceedings. And by contrast, the respondents here are asking for deference to OMIG, which Atlantic Care Management says is not responsible for administering these regulations and can't second guess the judgment calls of DOH.
Counselor, as it relates to the reading of subsection F, it seems to me that section was designed for this type of situation where you have public financing, lower interest rate, and then you have this consequence at the end that the mortgage is discharged early. And the fact that's how this transaction was structured originally. It was modified along the way when we brought in the Village of East Rochester Housing Authority, but it was the same exact financing structure that regulation appears, at least on its face, to control.
So I understand why you're looking at the structure, Your Honor, but if all you needed to do was look at the structure, then the phrase public finance authority would be unnecessary and it would be surplusage. And that's just not how I would submit that's not how courts read regulations here.
If the home hadn't refinanced from DASNY, the dormitory authority of the state of New York, to the East Rochester Municipal Authority, then F would apply, right?
Yes, Your Honor. That was our position.
But I think what just Delfante's point is that you have F applies if it's a dormitory. You say C applies because it got refinanced to East Rochester Municipal Housing Authority. What Justice Conte is still saying is that the structure of the financial arrangement is exactly the same, and it wouldn't make any sense to treat them differently.
Well, I think that's where our points about the the section 7 of chapter 913 of the laws of 1957 comes in, and where the authorities that we put forward in response to the draft audit report and in the ALJ hearing come into play, which is, since the 1950s, the New York legislature recognized that there are fundamental differences between municipal housing authorities on the one hand and public authorities on the other, and they wanted to clearly define the two. And pursuant to that, both the comptroller and the authorities budget office here, who are responsible for overseeing public authorities in New York, have said in papers that we provided to OMIG during our audit and in the ALJ hearing that municipal housing authorities aren't considered in public authorities in New York.
There's a controller opinion that says otherwise.
The one from the 1980s, yeah, but yes, that is correct. But I would submit that looking at the more recent comptroller, more recent comptroller report that reflects its current understanding and what its understanding was at the time of mortgage forgiveness, at a minimum needs to be addressed by OMIG and the ALJ, and neither of them did. So it's both a problem in terms of on the substance of the meaning of the regulation, but it's also, this emphasizes why OMIG's audit adjustment and the ALJ's decision are arbitrary and capricious, because we put forward these contrary authorities, both in response to the draft audit report and in the ALJ hearing, and the OMIG didn't address them explicitly. The ALJ didn't address them at all. You
weren't hiding the ball. I'll give you that. Do you want to, in the time remaining, address the estoppel?
Yes, Your Honor. Yes. On estoppel, as we point out in our briefs, it's actually undisputed that the administrative law judge erred by refusing to apply the governing test for equitable estoppel here. And while estoppel against a government agency is relatively rare, it is available where an agency knowingly or negligently misleads a regulated entity into justifiably relying on an incorrect representation. And if any case would justify estoppel, we would submit it's this one. DOH knew its repeated representations, both assuring Jewish Home that subsection C's default rule would apply, and then applying subsection C to years and years of Jewish Home's rates.
We understand your client was planning on this greenhouse renovation, and they were relying on this interpretation to finance that and the financial implications. So we understand that, and we appreciate your argument.
Yes, thank you, Your Honor. I think just to close briefly, I do think it bears emphasis that affirming OMIG's audit adjustment here would actually result in unjust enrichment to the state. As we point out in our briefs, the audit period for the 2017 rates has now passed. It's a 6-year audit period, and actually the audit regulations state, I think it's 517, 517.3A states that audits are intended to check the underlying book. It says books and records must be made available for 6 years to audit. And in this respect, rates are provisional. It does not say that rates are provisional in all respects. But on this unjust enrichment point, because the Jewish Home's 2017 audit rates are now final, the decision to apply subsection C and the full amount of Jewish Home's mortgage forgiveness to those rates, it also is final. And if OMIG was now allowed to apply subsection F and the public authority rule to other rate years subject to audit, OMIG would reduce Jewish Home's Medicaid rates by more than either subsection C's default rule would allow or subsection F's public authority rule would allow, because it effectively allows the state to apply both regulations to Jewish Home's rates when only one of them is supposed to apply. And we respectfully submit that respondents should not be able to obtain this double recovery, particularly when respondents' own position, as noted in the Atlantic Care Management case, is that OMIG has no legal authority to make precisely the type of methodological adjustment it made here, because interpreting the Medicaid rate setting regulations necessarily implicates a judgment call about what methodology applies. Thank you for your consideration. I would be happy to answer any further questions. Otherwise, we would respectfully request that this court reverse and annul the arbitrary and capricious and legally erroneous ALJ determination that upheld OMIG's arbitrary and capricious and ultra vires audit adjustment. Thank you.
Thank you, Mr. Moody.
Good morning, Your Honors. May it please the court, Brian Lusignan with the Office of the Attorney General, representing respondents. OMIG's conclusion that subdivision F of section 86-220 applied to petitioner's $10 million in forgiven mortgage is supported by the law, the facts, and policy considerations. Municipal housing authorities, like the Village of East Rochester Housing Authority, or I may refer to it as VERA, have long been recognized to be a type of public authority, albeit one subject to the public housing law rather than the public authorities law. Because VERA is a public authority, it could offer favorable refinancing terms that allow a petitioner to have its mortgage forgiven 10 years early, eliminating $10 million in mortgage debt. And by applying subdivision F, OMIG ensured that Medicaid reimburses petitioner only for mortgage principal that they actually have to pay. DOH correctly affirmed OMIG's determination, and this court should confirm. I'll start with this argument about OMIG impermissibly second-guessing DOH rate-setting methodology. That argument is not preserved and is thus not before the court. In their reply brief, petitioners mentioned that administrative exhaustion can be forgiven where an agency exceeds its jurisdiction. Preservation, however, in an Article 78 context is an unpreserved issue is not an issue of law and is therefore unreviewable in an Article 78 proceeding. And that's a matter of Con v. NYS DOH. It's 96 NY 2nd 879, 2001 court of
Well, I
appeals
think
decision.
their argument is a little bit, their position is we didn't make any mistakes in reporting our numbers. There's no fraud here. We're not attempting to disguise anything. We reported this cost in a way that was consistent with our meetings with the DOH and our understanding of the regulations. And then we were our rates were set, and then we had some additional proceedings, and then OMH restructures the cost reports in a way that's inconsistent with DOH's regulations. That's their position about the authority. That the reinterpretation of the statute attempts to show some kind of fraud or mistake when they were following the accepted practice.
That's their position before this court. That's not the position they took in response to the draft audit report. OMIG has regulations. It's 18 NYCRR 519.18A. That's also cited in our brief. An issue must be raised in response to a draft audit report, or it is not preserved for administrative hearing or judicial review. The third department's decision in matter of Wegman, which is also cited in our brief, is to the same effect. In response to the draft audit report, all that petitioner argued is that the village or that VERA is not a public authority, and that therefore is the only issue that they preserved for judicial review. This exception, even if administrative exhaustion, if this exception applied, it only applies which is to say that administrative exhaustion is only excused if an agency acts, quote, wholly beyond its grant of power, end quote. That's in the Watergate 2 Apartments Court of Appeals decision cited in the reply brief. OMIG has statutory authority to review and audit cost reports. That's right in the legislation, Public Health Law, Section 32, Subdivision 14. It has various regulations setting forth how it reviews all fiscal and statistical records and reports of providers, and can recoup any overpayment, which is any amount not authorized to be paid, including if it's paid by simple mistake. In other words, there doesn't have to be an intent to defraud the system for OMIG to recoup the overpayments. And with respect to the cost reports, they are provisional until they're audited by OMIG. So, even if this court were to reach the merits of their claim, OMIG is not bound by the fact that DOH accepted these cost reports. And the only evidence of a contrary position being taken by DOH is, recollections that one particular employee of DOH told them subdivision C applies in a closed door meeting with petitioner's counsel. That's not how policymaking decisions are made. That's not how any
DOH took a position that municipal housing authorities, like the Village of East Rochester Authority there, are not public finance authorities under subsection F. That's the policy of DOH, which is what the nursing home wants us to conclude here. Does OMIG, can they come in and say, do an investigation, say, no, that's not how we interpret it and we don't agree with that? They don't have that kind of authority, do they?
I don't think so. If you're talking about a policy that's in writing somewhere, that's possibly would have to go through notice and comment rulemaking to be
Not
adopted.
written down, but this is how we do it. You had Mr. Simpson here allegedly going to the meeting and saying, yeah, you're right, C applies.
Again, if there was a course of practice that could be cited, I've not seen any evidence of that, though. All we have is this one meeting with petitioner's attorneys, and it was made in response to a presentation that said subdivision C applies.
There are some follow-up emails. I mean, there are some follow-up emails saying, we had this meeting, this is our understanding, we're moving forward, we want to hear from you if there's some concern. And I think from their position, the only unanswered question was, do we report this in 2015 or 2017? That was, I think, the last set of correspondence from the nursing.
There were correspondences, and what you have is petitioner repeatedly asking DOH to confirm in writing that this is the policy, and DOH never accepted that invitation to confirm this policy in writing. And you can see in the audit that OMIG actually, they reached out to DOH and they said, this is their understanding. Is this in writing somewhere? Is this a DOH policy that you have? And DOH said, no, this is not our policy. And nobody's produced anything written from that time period announcing that policy. In fact, the only contemporaneous written document is an email that says the subdivision F, not C, applies. It's not clear that that was ever communicated to petitioner.
Under the accounting principles of how the rates are set, based on cost minus money that comes in, does it make any fiscal sense to apply it under F, or would that lead to the home getting the benefit of higher rates for costs that are greater than actually incurred?
That's exactly right, Your Honor. The capital costs component has there's two parts of that component. There's mortgage interest and mortgage principal. The mortgage interest goes away when they stop paying interest. In other words, that's reimbursed on a rolling basis as they pay it. So once they stop paying interest, they stop getting reimbursed for that interest. But the mortgage is baked into the value of the property, which is then reimbursed through this complicated depreciation process over the estimated useful life of the facility. Happens to be 40 years, same length of the mortgage. So, you know, petitioners also never provided any reason why DOH would adopt a regulation that would have a $5.5 million consequence for the taxpayers of the state of New York based on whether it's financed by the dormitory authority, which all parties concede would be a public finance authority, or a different type of authority, such as a municipal housing authority. There's never been any reason provided why DOH would adopt such a regulation, whereas DOH's position really harmonizes the whole, the rate setting and the regulations and the policy considerations.
DOH is trying to get the rates, the reimbursement rates, to have relationship with the actual cost so that it's fair to all providers.
Right. When that $10 million was forgiven, that's $10 million in mortgage principal that they didn't have to repay, that had already been baked into their rates. And just on that point, I realized in reviewing our brief that on respondent's brief, page 28, I refer to mortgage interest expense. That should say mortgage principal. Mortgage principal is what was forgiven and is what really is that issue in this proceeding. Unless your honors have any further questions, I would rest on our briefs.
Thank you very much. We will go back to case 29, Joshua Irwin versus Sarah Snyder.
Your Honor, we reached out and it went to voicemail.
Mr. Pulver?
Yes.
He signed in this morning, but now he's not answering. We will deem it submitted, and we'll give the other attorneys a chance to be heard. Ms. Constant, go first. Before you do, though, we have my understanding that the father's visitation rights have been suspended indefinitely pursuant to an order signed by Judge Reed on December 29th, and there's a actual return date of today at 11:30, which is might be going on right now. Is that your understanding, or is this news to you?
That's news to me, sir.
It's also news to me, Your Honor.
Yeah, we have an order from Judge Reed suspending the appellant's visitation rights. And his attorney may be, that's a virtual appearance return date today in Ontario County. Maybe that's where he is now, but so this might become moot at some point, but in any event, Ms. Constance, you wish to be heard with respect to his request.
I will keep it very short. The family court was obviously in the best position to make this determination and made the correct determination based on the actions of the father. While he might have been exercising his visitation, he had not followed through with other provisions of the consent order, such as not feeding the daughter food. He's not taking her medical diagnosis seriously and is actually risking her health by claiming that it's okay, he can feed her, or relying on his 70-year-old mother to handle those things. He's also failed to enroll in the anger management classes, take his mental health seriously, and has not taken the state-approved child parenting class. So we also submit that it's not in this child's best interest to increase his visitation. Obviously, he still needs to be supervised because of his failure to follow through with not feeding her or giving her any drinks. And we would rest on our brief unless there's any questions.
Just procedurally, the father's petition, he called himself and he testified and he was crossed. The mother, who's your client, correct?
Correct.
Called the witness out of order first. And then the court dismissed it, the petition for failure to state a cause of action. That's what had the mother, did the mother finish her proof? Was she going to testify herself?
I'm not sure if she was intending to testify or not, but I think based on what the father put forth, the court determined that there wasn't anything that he was going to bring up. The mother's testimony wasn't going to refute anything that the father.
This was
had
like a
raised.
directed verdict in a civil case. If the plaintiff testifies and no matter how true you say you can't win, that's what you think happened here?
That's my take on it, yes.
So if we were to determine that that was error and he did state a cause of action, what then would we admit it so that your client can put on proof?
I think based on the best interest of the child, you still find that the father doesn't need, didn't get to the point where he should get more visitation. The best interest of the child, whether he showed a change in circumstances or not, the best interest of the child still comes down to he's not taking her health into consideration and he's putting her health at risk by feeding her and not following those provisions of the consent order. So I think still based on the best interest of the child, you come to the same conclusion.
Okay, so
whether the mother testifies or not.
So counsel, my reading of the record though indicates that the testimony about the father feeding the child came before there was a direction not to feed the child. Am I reading that incorrectly? Timeline?
I think that was in right from the beginning, was that was part of the provisions that he was not supposed to feed this child. She had medical issues from her birth that feeding her undiluted liquids and certain solids she can basically aspirate. So I think that's always been in there. It's always been part of her health problems. And I think he's always been told that that was not something that he should be doing.
Okay, now this proceeding that may be happening right now, I'm assuming that neither of the attorneys before us here today are part of that proceeding.
No,
just on appeal. Okay. Do you know anything about the subsequent proceeding that's happened since the court's early?
No, unfortunately, I haven't had any notice from my client saying, what's been going on. I reached out ahead of this and just haven't. I think probably she's in the midst of this and just didn't get a chance to contact me back.
Or the nature of what that proceeding's about. We don't know, how that might affect anything we do here.
Not really, no. Unfortunately, she didn't get back to me in time.
Well, feel free, if you wish, to submit a post-argument submission with respect to these subsequent events.
Okay, I will do that.
All right. And Ms. Gray, you are the AFC here.
Yes, Judge.
Trial court's dismissal.
I do, Your Honor. My client is 6 years old. She's in preschool, pre-K. full-time. She does have significant medical issues that the mom is attending to, and the dad never even took a CPR course, which certainly would be helpful given her condition. So I fully support the dismissal of the petition.
But that CPR course was not part of the order that he had to follow. I mean, that was no, I don't remember seeing that anywhere.
I believe they talked about it, but you're right, it wasn't part of the order, but the no feeding, et cetera, was. He also never fulfilled, claimed he was kept out of doctor's appointments, et cetera, but he had an independent right to talk to the doctors, to follow her medical situation, and never followed through with it. He missed Father's Day last year, he missed 4th of July, he's inconsistent with his visits.
So you're more talking about best interest rather than whether the father sufficiently complied with the terms of that consent order to enable him to come into court and make an argument for more visitation.
Yes,
You're talking
Judge.
more about best interest.
Yes, Your Honor.
Okay.
Which the court never really got to. The court dismissed it for failure to state a cause of action. Last question for me at least is, this order was entered about 17 months ago, May of 2024.
Yes.
How has his compliance with the supervised visitation been over the last 17 months?
As I said, there have been a number of visits that he has not followed through on, so he hasn't exercised all his visits. And
Has the child been placed in danger in any form or fashion, any emergencies with respect to the medical condition?
not that I'm aware of, although he isn't complying with the no feeding or drinking.
All right. Thank you very much.
Okay, thank you.
Thank you.
Case 30, matter of J. Ron J. Appellant has submitted, the respondent is virtual. Supposed to be virtual.
Your Honor, she is now submitted too.
He is submitted. All right, we will move on. 31 and 30 and 31 are deemed to know. Case 32, East Side Parkways Coalition versus the New York State Department of Transportation. Case 32.
May it please the court, my name is Alan Bozer. I am counsel to Phillips Lytle. We represent Appellant's East Side Parkways Coalition and numerous other individuals on their appeal from a CPLR 3211 dismissal of their declaratory judgment action upon a decision that there are no grounds upon which relief can possibly be granted. The complaint pleads two claims. Number one, that the respondents violated the public trust doctrine by their alienation of what was once one of the most celebrated park settings in the entire world. Number two, that the respondents are violating the appellant's constitutional rights to clean air and a healthful environment by their continuing maintenance and operation of a superhighway that cuts through Buffalo's east side, a heavily and densely populated area. The judgment should be dismissed because the respondents failed to meet their burden of submitting documentary evidence that conclusively refuted the allegations. Now, the facts of the case are set up in the brief. At one point, beginning in 1873, there were 43 acres of dedicated parkland that came to be known as Humboldt Parkway. The parkland was alienated nearly a century later by the Department of Transportation without approval of the New York State legislatures. Now, the respondents do not deny that appellants properly alleged in their complaint the elements necessary to make out a cause of action for a violation of the public trust doctrine. There was parkland and it was unlawfully alienated. Further, the state's continuing operation of the limited access highway that took the place of the Humboldt Parkway is a continuing wrong because of the illnesses and unhealthful environment that it is causing to appellants. Turning to the public trust doctrine, I cite to this court's decision in Stevenson versus Monroe County from 50 years ago that Park areas in New York are impressed with a public trust, and their use for other than park purposes requires the direct and specific approval of the New York State Legislature, plainly conferred. I also cite to this court's decision 115 years ago in People X. Rel. Smith, which specifically considered Humboldt Parkway and decided that it was parkland. I believe that case is stare decisis on the issue of parkland.
Smith, my understanding, the issue was whether streets could traverse this Humboldt Parkway in Buffalo. And the court answered that question in the affirmative, this court. There could be streets that go through and across this Humboldt Parkway. Does that not, I assume that there, unless the state legislature alienated, say, Delaware Park, you can't have streets going through Delaware Park, right?
Correct, Your Honor.
But this court yet allowed streets to go through the parkland. This approach that they called it, Humboldt Parkway. How should we not read that Smith decision as if it allows streets to go through the parkland as opposed to the park, as treating it differently than a park?
Well, Your Honor, I'm glad you brought that up. And the reason is this, that under the public trust doctrine, if the legislature creates parkland, then only the legislature can take it away. In 1891, found this court in Smith. In 1891, the New York State Legislature plainly conferred authority on the Buffalo Park Commissioners that if they decided, they could allow a traverse street across the parkland. The reason I think this is stare decisis is that the entire decision in Smith revolves around the issue of parkland. If it's not parkland, then the legislature need not be involved.
So the state approved the traversing of Humboldt Parkway in Smith? The state legislature approved that?
Well, not exactly, Your Honor. The state legislature granted authority and plainly conferred upon the park commissioners the authority to do it. And the park commissioners did it. I think if you step...
Counsel, does that differ from delegating authority to the city to do it, for example? If the city wanted to put streets through, but the park commissioners objected, would our reading of Smith be correct that the park commissioners had the authority, the final word on whether or not to allow the cross traffic?
The state legislature can delegate that power. And this case held in the case involving Sierra Club, involving the putting of a school in Humboldt Park. The Fourth Department decided in that case that the state legislature had conferred upon the city, had delegated to the city, plainly conferred upon them authority to use parkland to create a school. So the legislature was involved there. Yes, the legislature could plainly confer on the Department of Transportation, which they did not in this case, but they did properly delegate in 1891 to the Buffalo Park Commissioners that if you decide, you may decide to have a traverse street across a park approach. And that was plainly conferring authority, and it all revolves around Humboldt Parkway being parkland. Now, at the time, to get some background on what was going on, there are a few cases, Holtz v. Deal and the Smith case and another, which talked about horses riding up and down Humboldt Parkway. And the reason was that the legislature granted authority was that Humboldt Parkway from Main Street all the way over to Delavan, a space about 1 mile, had no streets across. And in those days, 1890s, 1900s, the city of Buffalo was expanding. And so to get from one side of the parkway to another would require going all the way around this 1 mile long stretch. And so the legislature conferred authority upon the park commissioners that if you decide, you have the authority to cut a transverse road through. And again, the case revolves around parkland. The legislature was only involved. It was precisely involved because it was parkland. Only the legislature could grant it. And that's what this court held in
other words,
case.
it's parkland until it's not.
It's parkland until it's not.
And at this stage of the litigation, your position is we've stated the cause of action.
We have stated the cause of action, Your Honor. I think the explanation on the Smith case by the by the respondents that distorts the holding in it because it only looks at a part of it. The entire case revolved around that. We have a presumption of continuity under the law that once it's dedicated as parkland, it remains parkland until it's not, as Your Honor said.
My reading of Smith, if it wasn't parkland, there would have been no need for the delegation to the park commissioners.
That's correct, Your
The
Honor.
legislature wouldn't have had to do anything. The city could have just put cross streets wherever they wanted, but they needed the express delegation because it's parkland.
Yes, Your Honor. As a matter of fact, there was this dual jurisdiction at the time under New York legislative law that you had the Buffalo Parks Commissioners that had sole jurisdiction over the parkways. They had sole jurisdiction and they were the only ones who could with legislative authority do anything about it. The city of Buffalo had control over city streets, but had no control over the parkland that was known as Humboldt Park.
You would acknowledge under the Court of Appeals case that's cited throughout that there's a distinction between a parkway and a park. I think, is it your position that parkland, the public trust doctrine applies to park land? Park land includes parks, it includes park approaches, and it includes parkways. And that's the distinction there. It's a broader umbrella. Public trust includes all of them, even though Humboldt Parkway may not be a park. Is that accurate?
Yes, Your Honor. It's a question of parkland, and that's what the Court of Appeals talks about. It doesn't talk about parks. It talks about parkland. And in saying that, you have to look at whether this land, for example, was dedicated as parkland or not, which Supreme Court did not do. In this case, unlike many other public trust doctrine cases, I can draw the court's attention to the express language of the Park Act, which in 1869 said the following. It was an act to authorize the selection and location of certain grounds for public parks in the city of Buffalo and to provide for the maintenance and embellishment thereof. Having expressed dedication of parkland doesn't require talismanic language. It requires an indication that the legislature intended for this to be parkland, and I point directly to the language of the 1869 Act. Your Honor asked, well, what about park approaches? What about streets, et cetera? I can refer the court to the Westchester Park Act of 1922, and the Court of Appeals weighed in and said, when it comes to the Hutchinson River Parkway, if anybody knows about downstate New York, it's one of those parkways that goes on. I believe Robert Moses may have been involved in getting it done. It goes on for about 16 miles. But the Court of Appeals held that the parks, the park approaches, and the streets connecting the same within the Hutchinson River Parkway system was all parkland. That's the Court of Appeals said that. And so we are in pari materia here because the Park Act for Buffalo talked about parks, park approaches, and streets connecting the same, just the way the Court of Appeals construed the Westchester Park Act. So we believe that.
Let's assume you get by the parkland issue. Then the question becomes, did the state legislature alienate it with the highway law 349E?
349E, yes, Your Honor.
349E, which authorizes an expressway along Humboldt Parkway continuing to East Delvin Avenue, so forth. Your argument is based on the word that it's along the parkway, not on top of the parkway? Is that?
Well, Your Honor, in construing 349E, in that statute, it does say along Humboldt Parkway. The way it says along Walden Avenue and it says along Broadway, along Main Street, none of those were converted into superhighways. That was something that the Department of Transportation did. But the important thing is, if you look at 349E, in two instances, the legislature pointed to parks which would be affected, and that was in Albany, the Washington Park, and in Syracuse, Clinton Street. And it's notable that the legislature felt that it had to go out of its way to say, in those places, you can have depressed highways.
Right. It was definitely different language with respect to those two, but along Humboldt Parkway, it authorized. Now, it doesn't mean that all the municipalities had to build these highways, but they authorized the expressway along Humboldt Parkway. Your interpretation of along is that you have Humboldt Parkway, beautiful expanse of trees and so forth connecting the parks, that the legislature envisioned putting an expressway, a superhighway, you called it, directly adjacent to the Humboldt Parkway?
Well, Your Honor, if I may clarify an item, you said that it provided for an expressway along. It's a statute about state arterials, and state arterial.
State road, yeah, highway.
State arterials are not superhighways.
Well, it says highway, state highway.
And the word highway, I tried to point out, highway means any place where there are public vehicles proceeding. And that has to do with drives within Delaware Park. There's a ring road in Delaware Park. That is a highway under the law by the way highway is
So in your
defined.
view, the legislature envisioned allowing a highway, a state highway, to run all the way along this beautiful parkway. That's what they intended.
I believe and I think the record bears out that the legislature said that you can use, we're going to call this a state arterial, and the city will have access to funding and maintenance of the state arterial. So that, as with Walden Avenue, state money is now available because Walden and Broadway and Buffalo are used by people from outside the city to come into the city. It's only fair that Buffalo, one of the poorest cities in America, is reimbursed by the state to maintain these state arterial highways. So they existed, and because they existed, now state funds are available to maintain them. And that's what it says. So I say, we put forth in our brief that if the commissioner had simply taken between the curbs on Humboldt Parkway, the asphalt, the old drives, they were park drives, but had he limited himself to the jurisdiction he was granted over the highway, which is between the curbs, we would not have this problem. The green swards, the green spaces where horses were ridden up and down, where people would walk and picnic and play games. There are affidavits in the record about this. That could have been untouched. As a matter of fact, there is information out there showing that when the DOT first did their construction, they left the green swards. And you can find photographs that they left the green swards, and only years later they came back and knocked those down as well. But no, 349E is not a statute of alienation. It is a statute for operations and for maintenance of the highways. It did not plainly confer. And this is a gaping hole in the respondent's argument, because the Court of Appeals over and over and over says that if you're going to alienate parkland, it must be plainly conferred. The word alienate shows up nowhere in 349E. Taking parkland shows up nowhere in 349E. So if that's the best that the state has, it is not an alienation approved by the legislature. Your Honor, we have a second claim under the Green Amendment. The Supreme Court did this reviewing court no favor by failing to articulate any reasoning whatsoever for the dismissal of the constitutional claims we brought under the Green Amendment. Therefore, its decision is entitled to no deference. So what can the court do? As a reviewing court, you could remit to Supreme Court to give its reasoning for it. We don't believe that's necessary. Under the Court of Appeals decisions on liberal pleading in New York, like the Campaign for Fiscal Equity, which had constitutional claims, it's a question of whether the respondents had notice of what we are talking about. And there is no way that anybody can say that the respondents in this case had no notice of what we were talking about. And we're talking about an area which has the highest rates of respiratory illness, highest rates of asthma, lowest life rates in this one area. So the Green Amendment, which preserves the rights of the people to clean air and a healthful environment, is properly invoked. This is a wide open area for jurisprudence. It's for the courts really to take this constitutional matter and flesh it out. But you have no record here.
Incredibly vague language in the Green Amendment. You're entitled to clean air and water, healthful environment. You did state the claim. It would seem, however, that the Green Amendment could be argued on either side of any project. Like you could have opponents of filling in Kensington Parkway, raise the Green Amendment, people live in the area, and they're talking about, well, now all those traffic was 175,000 vehicles a day, they're going to be coming through our neighborhoods, and that's going to pollute our air. So it just seems so vague as to be unenforceable.
Your Honor, I submit that this court deserves a full record of the medical issues involved with the healthful environment part of this. And you deserve a full record on how the air is impacted by 75,000 cars a day being induced through this area. Because make no mistake, people used to come to downtown Buffalo along Broadway, Genesee, Sycamore. Those streets are absolutely deserted at this point. There's nobody on those streets. And it was induced for people to come through 75,000 cars a day. What did that do to the area? I live near the east side of Buffalo, and the east side of Buffalo has suffered terribly from what happened, both from a health standpoint and also from the standpoint of the economics of that area.
Yeah, I guess it would be an issue of fact in your view is what is worse for the environment?
What is worse for the environment?
To have them go, all these vehicles, either they're not going to come to the city of Buffalo at all, or they're going to be, if 33 is filled in, and they're still coming to Buffalo, they're going to take these side roads where kids play touch football on the street, people on the porch, which is worse, I guess. But you're saying that's not before us yet.
Your Honor, these are very good points. Putting traffic back on Broadway in Genesee and Sycamore is going to revitalize that area. If it's a balancing test under the Green Amendment, what do? We have all sorts of benefits that can be shown, but we have no record to present to the court at this point. I do want to.
Before we leave the Green Amendment, we have the related climate proceeding, the Article 78 proceeding, where it looks like there were Green Amendment claims that have been upheld so far by this same court. Explain to me how that's different from what we're claiming here. What were your clients claiming here?
Well, Your Honor, the Article 78 proceeding was successful. The New York State Department of Transportation has $1 billion and more to spend on this area. So it's serendipitous that we're here now at just the prime time. The Article 78 was successful, and we received a permanent injunction against the Department of Transportation based in part on the Green Amendment that Judge Koliakovo cited in his decision. What we're saying is that the continuing operations and maintenance of this high-speed expressway through a densely populated area is violating the constitutional rights of our people. Again, this court deserves a full record. The Climate Leadership and Community Protection Act, CLCPA, requires the state of New York to reduce auto emissions, et cetera. That is part of the claim, and Judge Koliakovo looked at that as well. So he granted that relief on the Article 78, but he made no reasoning as to why it did not apply to our case, which raises the injuries that our clients are suffering as a result of the ongoing maintenance and operation of the highway. Your Honor, I appreciate your attention, and thank you very much.
Thank you. Move on to Mr. Lee.
Good afternoon, Your Honors. David Lee, Assistant Corporation Counsel for the City of Buffalo. If you look at the amended complaint, the allegations are certainly directed toward the state of New York and not the City of Buffalo. The City of Buffalo did not violate the petitioner's Green Amendment rights because the city does not operate or maintain this highway. And the city did not violate the petitioner's public trust doctrine rights because it was the state, not the city, who constructed this highway over 60 years ago. And unless the court has any questions, I'll rest on the city's brief. And I guess I would only add before wrapping up, unless the court has any questions, that the City of Buffalo does not have any jurisdiction over this highway. The only municipality that retains jurisdiction over this highway system set up in the highway law is the City of New York. And for those reasons, Your Honors, the trial court judge correctly dismissed petitioner's amended complaint as against the City of Buffalo.
Thank you.
Does the city own the property? Did the city at the time, did it own the property?
Yes, Your Honor. My understanding is that the city owns the land on which this highway was constructed by the state of New York.
But the allegations here in the petition in this action are directed primarily at the state DOT, not at wrongdoing the city of Buffalo engaged in. That's your understanding.
Yes, that's my argument, Judge, and I think that's clear by just reading the amended complaint itself. It really barely mentions the city of Buffalo, and nor could it, for the reasons that I just briefly stated.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Ryan Lustignan with the Office of the Attorney General, representing the New York State Department of Transportation. The legislature selected the route of the Kensington Expressway. However short-sighted that decision may now seem, it is fatal to plaintiff's public trust cause of action. By selecting that route, the legislature also necessarily required the state to maintain the expressway in a reasonably safe condition. Nothing in the text or history of the Green Amendment requires the state to abandon its obligation to maintain the Kensington Expressway. In fact, according to the information available to the department, closing the Kensington Expressway would result in the diversion to surface streets of 75,000 vehicles per day, causing massive gridlock, increased air pollution, and dangerous conditions for pedestrians, cyclists, and motorists in the surrounding communities.
Is it premature to come to those conclusions? This being a 3211 motion?
If plaintiffs are trying to compel the department to abandon its obligation to maintain the expressway, the only information currently available, it shows that would be a massive problem. And that's information that's in the record.
That's why it was built in the first place. That's why the
Right.
expressway was built in the first place, to alleviate the traffic problems for the folks who are living in that area.
Correct.
Cars coming by, would it be different today? I don't know, but I'm not sure that's the dispositive issue here. Could you give me your interpretation of the Smith case? And how does that inform our decision here?
So what's clear from the Smith case is that this court distinguished between Humboldt Parkway and the parks themselves. That's Delaware Park and et cetera. And specifically, the legislation that there was authorization for these park commissioners to allow streets to cross the parkways, and the commissioners had sort of allowed, I guess, the city to build these streets without formally authorizing it. And what this court held is that the commissioner could not then turn around and say, we're going to close those off. I mean, if it had been park, I think there'd be no question that they couldn't have allowed the streets to cross it. But I think Smith is, it's maybe not directly on point with this case. And I think you can avoid all these issues about whether or not Humboldt Parkway is a park, or whether specifically the median is a park, or is it a park approach, or whatever, because for better or worse, the legislature in 1947 told the Department of Transportation where to put a state arterial highway, and it chose the Humboldt Parkway, the route of the current Kensington Expressway.
Can we talk about some of the language? Because you see Washington Park and you see Clinton Square, you have the comparisons. Both of those situations, the language is that the legislature especially said that portion of the arterial route within and in the vicinity of the park, within and in the vicinity of Clinton Square, may be built as a depressed highway. In both of those situations, the language that we have regarding Humboldt Parkway is different. It just says it said no mention of a depressed parkway or depressed highway, and nothing, no language about within and in the vicinity of the park. So why shouldn't we consider that to be a difference? We always look at differing language and say, well, it must mean something different. Why don't we do that here?
Well, the legislature likely didn't consider it a park, and that's why it didn't say anything about in the vicinity of the park. Also, I'm not sure the situation we're in would be any different if they hadn't built a depressed highway. If they had 6 lanes of traffic on either side of this 86-foot wide green median, I think there'd be a very strong argument that would also be an alienation of park uses. And furthermore, saying that they can build a depressed highway, they still didn't say, or the legislature still didn't say you can alienate parkland. They didn't use that language, that talismanic language that plaintiffs are looking for. So clearly legislature in those situations imagined that there'd be or authorized some alienation of parkland, even though it didn't say specifically, and you may alienate parkland in furtherance of these duties.
Along Humboldt Parkway means on top of, in lieu of?
Well, Humboldt Parkway is still in existence. There's two surface level streets on either side of the Kensington Expressway. So they didn't, yeah, you're right. It clearly, I think, in retrospect, seems to be a short-sighted decision to put this Kensington Expressway where they put it. But that's where the legislature told the department to put it. And this highway law does a lot more than just transfer funding obligations to the state. It directs the department to prepare designs, plans, and specifications for the construction, delegating to the department that authority. It says that the state arterial highway may be constructed or reconstructed of such width and type of construction as determined by the Commissioner of DOT. That's Highway Law 349C sub 2.4. So the legislature can delegate to state agencies the authority to just as it can delegate to a municipal authority, the authority to convert one public use to another public use, because streets, the Kensington Expressway is also a public use. In other words, as in a private party came in to do something. And I think the case that's most on point, and it's an old case, is in re City of Buffalo. And in that case, the Court of Appeals held that the legislature's delegation to the city of Buffalo of the general authority to take land to build a canal didn't allow the city of Buffalo to take basically a railroad switching yard. You couldn't decide to put the canal straight through the railroad switching yard. But the Court of Appeals went on to say the situation would be different if the legislature had selected the route for this canal. I think in the example in the case, they're talking about a railroad. It's one of these great 19th century cases where they go on and on about a bunch of sort of tangentially related things. But the bottom line is that what the Court of Appeals approved of is saying if the legislature picks the route, they necessarily have made the decision that the public use along that route is going to now be railroad, canal, in this case, highway. So the legislature made that decision, and the department was bound by that choice.
Is there anything that would stop the legislature from passing a law right now to do the alienation that you believe has already been done, but they don't?
Correct, Your Honor.
Clear up the record and pass the law and say we're gonna alienate this.
The legislature
forward.
Yeah, they certainly could do that. I don't know that the wisdom of such a decision at this point. I mean, it would clear things up for us, but again, I don't know that many legislatures today would stand by the choice of that 1947 legislature to put this thing straight through Humboldt Parkway. And with respect to it, whether or not this is a park, I'd actually suggest that if Your Honors can avoid reaching that issue and just base a decision on the alienation made by the legislature, that would be the narrowest and best way to resolve this, because plaintiffs have alleged that there are other parkways that are still largely intact. So a decision about whether Humboldt Parkway is a park might have unintended consequences for the status of those other.
Does alienation
parkways.
arise only from 359E of the highway law? Is that your entire alienation argument is based on that statute?
That's our alienation argument, yes.
No other ways that it was alienated?
Not that we've argued, Your Honor. And just responding to those Westchester County cases that were flagged in oral argument, I mean, this is really interesting because the Westchester Park Act actually defines a park to include streets, roads, docks, and bridges, things that clearly are not park uses. And one of the things Robert Moses was known as is the best bill drafter in Albany, and he was known for burying in the definition section of a statute enormous powers for his public authorities. So I would argue that those Westchester County decisions should be limited to the specific context of that Westchester Park Act, as opposed to general public trust doctrine principles. Unless Your Honors have other questions, I'll rest on our brief.
Thank you.
Thank you, Your Honors.
Well, case number 33 is Alecki versus Tech Park Owner LLC. Yes, we'll wait for Justice Bannister. Justice Del Conte has recused on case 33. So we will resume when Justice Bannister joins us. Appellant's counsel is remote. No problem. Mr. Storrs, you may proceed. Your opponent has submitted.
Thank you, Your Honor. I'm just going to keep this very brief if it pleases the court. Our appeal is strictly based about jurisdiction, not neglect on the part of Tech Park LLC. As you're aware, LLC Law 303 requires mailing by the Secretary of State, but there's nothing there that defines that there's been the receipt of the lawsuit. The mailing was never received, and without the receipt of the mailing, we were unable to respond. Therefore, there was no jurisdiction established by Kimberly Alecki in this case. 303 requires two different things. One, it requires delivery to the Secretary of State, but it also requires the Secretary of State to mail by return receipt to verify that the lawsuit was received by the defendant. A sworn denial by my client doesn't necessarily mean that there was a conclusory issue, that it was not a conclusory statement. Denial to receive the statutory mailing the correct address for busted service. If there is no affidavit, their jurisdiction is not established. Therefore, there was a mandatory hearing to decide whether or not the service was in fact effectuated.
I think, am I correct that you're saying that the defect here, it wasn't that plaintiff didn't serve it on the Secretary of State, it's that the Secretary of State didn't then mail it on, right? Because we know the Secretary of State got it from the plaintiff, right?
Yes, Your Honor. It was delivered to the Secretary of State, and I do understand that what the case law says, but there's no proof that the Secretary of State completed the service to our client.
Right. That's where the mistake, if one was made, it was made by the Secretary of State. And I get it's hard to prove if your client didn't actually get it, it's hard to prove that. It's hard to prove that you didn't get something, right? But
yes, Your Honor.
Your client did get other mail from the Secretary of State. So we know it was the right address, right?
We do, and the client has been responsive. I mean, this is not their first rodeo, so to speak. They are responsive to these suits, and they do respond in kind. They did not receive this, and that's what the affidavit states. I know the affidavit is easily dismissed as self-serving and conclusory, but it is a sworn statement stating that it wasn't received. That this lawsuit was not received, and at the very least, there should have been a hearing on those grounds to determine whether or not service was completed here.
All right, we'll take a close look at that. Anything further?
No, Your Honor, I will rest on that. We'll not waste any more time. I'll rest on that unless you have any more questions.
Thank you, Mr. Storrs.
Thank you, Your Honor.
We will move on now to case 35, Charcola versus Channel 13 News.
Good afternoon, Your Honor. May it please the court, Vivek Diagaraj on behalf of my client, Daniel Charcola. We're here because my client is being obligated to pay hundreds of thousands of dollars for him to just articulate the fact that nothing happened according to a newspaper article came out. Now, the key issues here is that we're looking at Civil Rights Law 70A regarding a defendant. Here, it's undisputed that the defendant here actually did not pay any of the fees or legal costs related to this. Rather, it was another entity, not a party, not a defendant, Sinclair, that was invoiced and paid such invoices. I would bring the court's attention to the Comerick case, which was actually argued before this court back in 2019, where it specifically outlined how critical it was who actually paid the invoices regarding the recovery. Here we're limited to the words of the statute. I'd also bring the court's attention to a case that was actually decided by the Court of Appeals after our final briefing. It was on November 20th, 2025. The Court of Appeals ruled in Garcia versus WTC Volunteer. It's slip op 2025 NY slip op 06360. Where it was very clear there in that case, a woman whose husband unfortunately had passed away related to a volunteer action regarding to 9/11, the Court of Appeals determined that it was mandated to follow the exact language that was set forth by the workers' compensation law. The legislature stated what the language was, and they had to follow that language in order to award any type of recovery in that scenario.
Counselor, what if the fees are paid by an insurance company?
Sorry,
what if the payer is actually the carrier?
so the question is, the statute only allows for the recovery of the payment here. The fact that the invoices were billed to a third party, that was not a defendant here precludes them from being able to.
So if there is a coverage for a claim, and the carrier operates under its contract and assigns counsel defends the claim successfully, and that litigant who has counsel cannot make the application for fees under your reading of the statute.
The way that I read the statute is the statute specifically states that the defendant must recover it.
Right, but let me just finish. Even though that client or that defendant can take the position, well, I've been paying premiums.
Again,
I've paid premiums previously, and my premiums are going to reflect the fact, my future premiums are going to reflect the fact that we just went through this litigation.
So I'd bring the court's attention back to the Fourth Department's decision in the Comerick matter, where it stated that it didn't matter that the shareholder actually was the one that owned the company that paid for the cost. They said it was irrelevant and they couldn't render such an opinion. So that fact pattern that's not here, I can't answer regarding it, but I would argue that the statute specifically states that the recovery would be a loss that have to be incurred by the party who's the defendant, which again, here's a third party that was not.
So if we were to adopt your interpretation, then a local news programming, in order to recover these fees, would have to decline coverage under these circumstances. They have to pay their own. They'd have to really just, if they had coverage from a carrier, they'd have to decline the coverage and pay their fees directly, hire their own counsel, and then under those circumstances, then they could recover under the statute.
My statement is that the statute specifically outlines how the recovery would have to occur. And so as a result, we have to follow, according to the Court of Appeals in that 2025 decision from 2 months ago, we have to follow exactly the language.
These other cases that you cited, the one from the Fourth Department and the recent Garcia case, those were not anti-SLAPP statutes. Those were under the civil rights law. Were they not? They were not.
That is correct. They were not anti-SLAPP statutes.
So part of the anti-SLAPP is a public policy determination from the legislature. They want to deter legal actions that might stifle free speech and coverage of controversial news issues. There's no deterrent. So part of it is to deter baseless claims. If you bring a claim and you lose, not only you got to pay your own lawyer, you got to pay the other lawyer under certain situations. Most of the media companies, at least the major ones, have coverage. You sue ABC, CBS, New York Times, they're all going to have libel coverage. They're all going to have carriers. So there would be no deterrent at all. So those defendants, you could sue them the most frivolous claim ever to try to prevent publication, and there would be no attorney's fees award, because why? The New York Times is not paying it, their carrier's paying it.
So if the court wants to make that position, obviously, I would go back to the cases that we actually have is the Gottwald case, which is an anti-SLAPP statute. And there, Ms. Siebert, Kesha, who is famous, and Dr. Luke, which is the lawsuit, she was able to recover her fees that she paid. Actually, in that scenario, the 2023 decision, it said it was going to go to a trial to make that determination. But again, that was a person that was defending themselves, and that was what was the intention, I believe, of the legislature.
But this isn't a carrier case, right?
It is not a carrier case, and we're stuck to the record as it is before us.
So we have a statute. Okay?
Correct.
And the statute allows the defendant to recover as damages, okay? The cost of the attorney's fees. Is this damages to your client if your client has no obligation to pay them?
I think that's exactly correct, Your Honor. The recovery would require there to be damages. With no damages, there is no ability to recover. Here, the defendant, which is using the statute after it has been expanded, has no ability to recover that which it has not incurred or billed or paid.
It might be damages. It might be able to be recovered if there was some relationship between you and the company that picked up the tab here. But we don't know what that is in this record, do we?
And I would agree that we don't know exactly what the relationship is. We don't have it in the record. I would also say that in the Comerick case, that case, which was before this court, and I know it well because I was here, there was clearly one owner that was a shareholder that owned the actual entity that made the payments. The court here stated that that was irrelevant to the analysis.
Because they weren't a defendant. Like, let's say, look, there is, Justice Bannister correct, and I scoured the record. There's no evidence with respect to the relationship between Sinclair and Channel 13 in the record. Go outside the record, you find out very clearly what it is. And they own the non-licensed assets of Channel 13. They may own the licensed assets very soon too. But regardless, they're not a defendant, even if they owned Channel 13 outright.
That is
all of your argument would be, regardless of the relationship, Sinclair was not sued. Therefore, even they may be contractually obligated with the affiliate to cover them. There's no fee award in this situation, even with the relationship.
Correct. If Sinclair had decided to intervene into the lawsuit or try to bring some type of action, or my client had sued Sinclair, it'd be a different statute.
So fees depend on which entity within you decide to sue. You can avoid it by just suing the one.
Well, again, I would refer back to the Comer case, where it specifically talks about how the entities have the ability to choose how they want to avail themselves of the corporate laws in New York State.
Well, also, we could have had a situation where the relationship is laid plain in the record, okay? You know, we're gonna pay, but there are certain duties on your part to repay us, or we don't know any of that. We don't have the engagement letter. We don't have any explanation except a footnote somewhere that says that they're affiliates. Now, I don't live here in Rochester or whatever, so I don't have that general knowledge of who's who in this media market, et cetera. So to me, I only have the record. And in fact, that's all we have to go by here is what's in the record. I have no idea the relationship.
And that's exactly right. And to be fair, Your Honors, my client is an individual that was accused of something that was not true. He doesn't have a wealthy or connected or some other entity that can pay his invoice.
Sue the people who lied about him.
Sorry?
He could sue the people, and he did sue the people who lied about him.
Yes, he did,
He
Your Honor.
sued the people who reported about the people who lied about him, but that lawsuit's over, and we don't need to get into that now, but.
And to be fair, Your Honor, I think your statement is the people that lied about him, they continue to say things that they lied. That was just the way. But he did sue them, yes.
Counsel, I have a question about the decision.
Yeah.
Page 5 of the decision, page 12 of the record. There's a line about the plain reading of Civil Rights Law 78. And the judge says clearly provides. And then.
Sorry. Page 5, you said?
Page 5 of the decision, page 12 of the record.
Okay.
The defendant may maintain a claim to recover attorney's fees, and then the court italicized from any person. And it looked to me that the argument was being made that from any person, the court was implying that the from any person referred to any person who paid the attorney's fees. But my reading of it is from any person who commenced or continued the action. That's the plaintiff's, right?
Yes.
It doesn't say a defendant or any person who paid attorney's fees can recover from the plaintiff. It's the for any person is only in the statute only pertains to the plaintiffs, the people bringing the action. Is that right? Is that your reading of it?
My reading is consistent with your reading on that regard.
Oh, thank you.
Counsel, I think you covered this issue rather thoroughly. Would you like to rest on the brief?
Yes.
Thank you.
Thank you.
Morning. Good afternoon, Michelle.
Good afternoon, Your Honors. I please the court. As most of my colleagues' counsel argument was spent addressing the fee issues, I'd like to begin there, if I may. I think Your Honors' questions get directly to the heart of this issue and exactly to the reasons why the court should reject plaintiff's argument here. Justice Del Conte's question, I think, points exactly at the issue of why plaintiff's argument that fees should not be paid here, awarded here to Deerfield, would create an absurd result.
To Deerfield or to Sinclair?
So, excuse me, I'm sorry, Your Honor. We're here. Deerfield Media is the defendant that plaintiff named. There's also a second defendant, the station's call letters, which is not a real entity.
Sinclair paid it.
Sinclair Broadcasting.
Deerfield and Channel 13 are one and the same.
Yes, effectively.
All right, I'm
It's
sorry.
the call letters and the actual owner of the station. Regarding the record, I respectfully submit that it is in the record. It's in our answer in the trial court, and I believe also in discovery materials that have been filed and may not be in this record, but in past appeals, that Sinclair operates the station and Deerfield owns the station. It's also in the record through FCC records, or a matter of public record through FCC records. So Deerfield Media is the defendant the plaintiff named. It is the defendant that litigated this case and that successfully won a counterclaim under the plain language of Section 70A. As Justice Nowak points out, and as Mr. Thiagarajan concedes, the language of that statute is clear. The defendant in a SLAPP action may recover from the plaintiff, from the person who pursued that SLAPP action, its attorney's fees and costs.
That's not what it says. It says may recover as damages, may recover damages. Now, to me, that's a very specific word that you left out, okay? Damages means something that, hurt me, okay? The damages were paid by some third party, not by any of the named defendants. So damages, do we just pay them to anybody who says I paid? Or do we pay them to the defendants? And I think that's a very important distinction.
First, thank you for the correction on the language of the statute. I apologize for the misstatement. But I think under the statute, the damages are paid to the defendant in the action. And then to the extent that there is a situation where another entity or an individual or someone else other than that specific named defendant actually paid the fees.
So
that's
where does
between
that say
those
that?
two.
Where does that give us the ability to do that? I don't read that anywhere in the statute.
I don't think the statute explains that. I think Your Honor is correct there, but I don't think the statute allows the court to, the statute or the Court of Appeals decision in Gottwald allows the court to refuse to award damages to a defendant who did appear and did submit competent evidence through an attorney affirmation attesting to the fees that were incurred and paid in this action.
What would you say to this hypothetical? Because we're always concerned about the next case as well.
Yes, Your Honor.
You see a lot of these legal defense funds. Somebody gets sued and then people go online, go fund whatever, and then donate money to defend so-and-so. And then that person wins and gets an award of fees. None of it came from the defendant, came from all these supporters. Does that person get a windfall of all the fees that somebody else paid on his behalf?
I think that probably then turns to whatever the agreement is between the funder and the defendant. I think that's essentially a separate issue that is separate and apart from what the court awards. It goes to, excuse me.
I'm sorry, but Counselor, the question is whether or not the court's prohibited from granting an award, not what the award would be. For instance, in Justice Lindley's example, the court could take a look at that and say, well, I'm going to apply the lodestar method or some other method, and I'm going to make a determination of what reasonable fee would be under the circumstances. That's left to the court. Question here in front of us is the broadcaster prohibited from recovering if they don't literally pay their fee directly from their own pocket or they're not billed directly? Because you can't pay it directly unless you're billed directly. And if you have coverage for it, you're not going to be billed directly. In fact, you're not even able to control the litigation necessarily under the contract with the carrier.
So to your question, Your Honor, no, I don't think that the court is prohibited from awarding fees to the actual defendant because someone else paid those fees on the defendant's behalf. In fact, I think under this language of the statute and under the Gottwald decision in Siebert, the court is required to award fees. And in light of this court's prior order affirming the summary judgment granted on the defendant's counterclaim in this case, the court is required to award the full amount of attorney's fees and costs incurred by defendant Deerfield Media. I understand the court's concerns about other entities, being paid, and that creates some ambiguity about what's happened.
But the fee still has to be reasonable. If the court awards a fee, it still has to be a reasonable fee under the circumstances.
Yes, Your Honor, it does. And that's an excellent point, because in this case, there is absolutely no dispute before the trial court or before this court that Deerfield's fees and costs were reasonable and appropriate under the lodestar method.
Wouldn't it be a windfall though if Deerfield, I assume it sounds like there's an agency agreement between Sinclair and Deerfield.
I assume there is.
Very rarely I think we're going to see these cases where some company just volunteers to pay the legal fees of some totally unrelated entity, say, oh, here's $500,000, right? There's some legal reason why Sinclair paid this. They're not in the business of just giving out money.
Yes, Your Honor, there's a joint services agreement.
Yes. So, but still, Deerfield gets paid here. You want $500,000 for Deerfield. Deerfield's not out a penny isn't that a windfall of 500 grand for Deerfield?
No, Your Honor, respectfully, I don't think it is because that assumes that the money stops there and that Deerfield doesn't have any
So
subsequent
they would
litigation.
have to give it to
Right.
Sinclair?
I believe there is, I don't know the exact terms of the agreement.
And that's the problem. We don't know because you didn't tell us, okay? We don't know where the money goes from there. You're asking us to make a big jump that the money that would go to this defendant would then be passed on, and you give us no reason to understand that in this record. It's my view.
Understood, Your Honor.
Yeah, it
With
did
all
seem
due
like
respect,
it did seem like there was a reluctance to explain this relationship. Maybe it's explained in another, this is the first one I've been on, but I was curious, like Justice Bannister, why is Sinclair just paying this? There's got to be some reason, and we just never really got that.
Candidly, Your Honor, I don't think it was reluctance. I think it was an assumption that this had been explained so many times over the course of the case to plaintiff's counsel, because plaintiff's counsel has attempted to litigate this issue a number of times in prior trial motions and appeals and everything else. So it was, if the court is concerned about this, we would respectfully request that you remand and allow us an opportunity to submit the joint services agreement, because on our view of the law, there's no requirement that we
Expand the
provide
record
that
at this point, but anything further, I think we understand, look, it's not a lot of authority. There's a trial judge decision out of Buffalo that goes against you. There's some out-of-state authority that may go in your favor. It's unsettled here in this jurisdiction, so we're gonna have to take a look at that one.
Counsel, I'm sure. Could I jump in one more question? And I appreciate where Justice Del Conte was going with the insurance context, and it occurred to me that the insurer who's been paid a premium has a duty to, of course, to represent, but also has an incentive to minimize the claim itself, because they're likely going to be paying the claim too. If there's a successful defamation claim, not only are they going to pay the defendant, but they're going to be paying on that claim in many cases. What if you have a situation where it's not the insurer with the same interest, but it's a party that has a separate interest? The party isn't really going to pay the claim. So in this case, if the plaintiff gets a verdict of defamation against Deerfield's responsible to pay that claim. Sinclair may not have to pay the claim. We don't know. We don't have the joint services agreement. We have no idea. What if what if Sinclair is doing this for an alternate purpose? Because they have other contacts in the media, they have other responsibilities nationwide. That's why they're choosing to defend the claim. So now there's an ulterior motive, a separate motive. Wouldn't it seem that we wouldn't be reaching the purpose of the civil rights law by ordering that payor to be reimbursed?
It's an interesting question, Your Honor. I think in your hypothetical, you're assuming there is some sort of nefarious or maybe less than.
I'm not saying it's nefarious. I'm just saying they have a different interest. They look at their books, they look at their business model, and they say, oh, gee, if we defend this is going to help us over here. I'm not saying it's nefarious at all. I'm just saying it's different.
That's possible in any litigation. That's a factor that every litigant considers. How does this affect my bottom line? What do I have to pay in fees? What's the actual risk of liability? What's the impact on pursuing an appeal or not on later jurisprudence? So I think that doesn't change the analysis. I think that would be adding, if we had to demonstrate the motivation of the defendant or the person who's paying the defendant, I think it would introduce an element that's not really required here by the statute. But I think the question of who's paying and why goes again to Justice Del Conte's original question, Mr. Thiagarajan, if I may briefly, which is there is a risk here that if the defendant who's actually named is the only defendant under the statute who's allowed to pursue the claim, and then someone else pays for them, and then this defendant now cannot recover your fees, you've defeated the purpose of the statute, because there are lots of reasons why somebody else might pay. Yes, there's litigation funders. Yes, there are insurers, but a news station might indemnify a reporter who was sued, an individual reporter. And if then the defendant chooses to only sue an individual reporter, that immediately defeats the purpose, because then the station cannot indemnify and this individual could bankrupt themselves paying legal fees before they get to the end. What if a law firm agrees to take the case pro bono on a contingency effectively if they would recover some portion if fees are awarded? This happens all the time in FOIL cases. So yeah, I think there's lots of
reasons.
There's
more than one purpose to the statute. One is to level the playing field.
Yes, Your Honor.
That's not served here. Deerfield doesn't need as far as resources. The other, though, is to deter these types of lawsuits that are intended to chill publication and speech.
That's exactly right.
One doesn't apply level the playing field, but the other one, in your argument, in your view, would.
Well, I think the one about leveling the playing field may apply if suddenly there's a requirement about the individual defendant who actually writes the check, because then you have the question of what an individual station can pay versus a corporate owner or a corporate operator. But to your point, yes, I think there is another really important concern here, which is deterring frivolous lawsuits. And while plaintiff's counsel insists that this reporting was false, he has never proven that. We didn't get that far because the reporting was privileged under New York's law, because he couldn't prove other elements. And to this day, Deerfield and this station stand by their reporting and the truth of it. Unless the court has other questions, I will sit down.
Thank you. Case 36.
Thank you, Your Honor.
EBF Holdings LLC versus Defiant Arms LLC, case 36. Mr. Grant is the appellant's counsel, and he is with us virtually and may proceed.
Good afternoon. May it please the court, Jack Grant from law firm Rupp Falsgraf for the defendant's appellants, Defiant Arms LLC and Dwayne Favors. These cases or similar cases have flooded New York's courts, so I don't want to belabor the point too much, but briefly, the courts in New York have made it clear that the title and content of agreements is not determinative in these cases. Rather, courts should engage in a review of how the agreement's terms operate in practice. In making this decision, it is our position that the trial court did not properly engage in the fact-intensive inquiry that was necessary, and this resulted in the improper denial of our client's motion to dismiss both the individual and the company defendant. And it also resulted in the improper granting of plaintiff's motion for summary judgment.
All right, why don't we get into the specifics if we could? You're familiar with the Sampson case that we adopted the third department's three-part test to determine whether you have a sale of assets or a loan?
Yes.
And then there was a dissent in the bridge funding case. Two of the dissenters are here on this panel. They had proposed a slightly different test. Let's start with the Sampson test, which is from the second department, which is then from a trial judge decision down there, Kate Bright, something along those lines. What, under that three-part test, how does the MCA here, where does it fail?
Absolutely. The main areas in this reconciliation provision that they have here, and frankly, in this case, the reconciliation provision isn't worth the paper that it's written on, as when our client actually attempted to invoke it, there was he was denied. There was no change in the
Well, wait a minute. Let's go through this carefully. The agreement requires, it says, if you want reconciliation, if the merchant has to ask in writing. Do I have that right? I can't find it. It's in front of me here. But you have to ask in writing, the merchant does, right? That's one requirement. And then it says,
that's my understanding.
Then it says, give us your bank records, your weekly receivables, and we'll compare them to what we're taking out, the $1,500 roughly, and we'll see if an adjustment needs to be made. Your client never followed that provision. And by the way, the reconciliation provision was not illusory. It says, if you do those things, you ask in writing and you show the bank statements are not proportionate to be what's being withdrawn, the buyer shall reset that amount that's to be withdrawn. Your client never availed himself of those rights under the MCA. Am I missing something?
Judge, I think there's an issue of putting form over substance here, where our clients did contact plaintiffs and advised that they were having issues with the amounts, that the amounts were too high. And so there should have been at that point, an initiation of this reconciliation provision.
Did your clients, did they provide the statements from the bank? They're supposed to have only one bank account and he had two, which is a problem in and of itself. But did your merchant provide the bank statements and say, look, this 1,500 that you're taking out, 1,551 is too much compared to what I'm bringing in. Did they do that step?
Not to my knowledge, but at the same time, Judge, I don't believe after there was a conversation of our clients recognizing or pointing out the fact that that the amount being withdrawn was in excess of the 15% that was agreed upon. There was an opportunity for plaintiff there to request the bank statements, and at least it's my understanding that that did not occur.
Counsel, I have a question that kind of goes to the burden here. I see what your client put in his affidavit that he made these attempts at reconciliation after the fact, and he talks about this issue with PayPal and the email account and a fraud alert that was put on by the bank. But he says, I tried to negotiate with plaintiff a lower weekly payment, et cetera, but then the action had been brought. I guess my question first is the plaintiff in this case, are they required in the first instance to say that your client did not avail themselves of reconciliation? Because I don't see that either, but I don't know that they have to. They do say we complied with the agreement. So that's in the motion papers initially. Is that sufficient? Did they meet their burden by just saying we complied, and then does the burden shift to your client to say, no, you didn't comply because you didn't comply with the reconciliation?
I mean, if we're going to adopt the plaintiff's position on this, then it would be, we put the reconciliation provision in the document, therefore we satisfied our burden now and forever. But I think there's also a pragmatic aspect to this where the plaintiff should have at least attempted, if their true interest was in having this paid, instead of just simply bringing a judgment and try, or bringing an action and trying to get a judgment, then there would have been an interest in trying to work with the defendants here to get payment done, and that clearly did not happen.
Well,
I hope that answered your question.
I don't think you answered my question as to whether they met their burden. But if we assume for a moment they did, that all you have to say if you're moving for summary judgment on one of these contracts is, we complied with our responsibilities under the contract, and the burden shifts to you. Does your client's affidavit saying that he tried to negotiate with plaintiff a lower weekly payment, does that create an issue of fact in the absence of a written statement, in the absence of the email to the correct email address, in the absence of the evidence that Presiding Justice Lindley was mentioning?
I believe it does create a question of fact, Judge, because it shows that there was the issue with these reconciliation provisions, and as has been pointed by courts in New York, is that it can't just be a reconciliation provision. It has to be a functional reconciliation provision. There has to be evidence that it was actually used. And in this case, our client has presented evidence in the form of his affidavit stating that he tried to get a lower amount, expressed to plaintiff that the amount that was being charged was in excess of the 15% weekly. And then instead of trying to work with him to get this paid off under the terms of the agreement and to have that non-finite term that they also preach in the agreement, they brought a lawsuit instead.
Right. Well, look, there's no need to negotiate anything under this reconciliation provision, which I have in front of me on page 18 of the record. There's no negotiation here. You're entitled to it under the contract. If you may request this reconciliation of the weekly payments to more closely resemble the seller's actual future receipts. And you got to do some few things. You got to put it in writing. You got to show the receipts. And then if you do all that, the buyer shall reduce the amount accordingly. Shall. There's nothing to negotiate here. You could have enforced your clients could have enforced the reconciliation rights under the contract, didn't even try to do so. That's the way the other side's going to look at this.
I understand how the other side is going to view this, Judge, and I think part of what needs to be taken into account here is that my client is not an attorney. My client is not going through these documents with a fine-tooth comb. He's a small business owner, and there like I mentioned, there needs to be, or it's our position that there should be some pragmatism with the plaintiff in seeing that there's an issue making the payments and trying to assist.
Let me shift to another gear, and this would apply if we this panel were to agree with Justice Nowak's test in the dissent in the bridge funding case. One of the factors that I understand it is how realistic were these monthly payments from the outset? What relationship did they have to the weekly receipts coming in? How close was that payment to the percentage? The agreement that your client signed, first page says monthly sales, average sales, $47,866. The amount taken out was what, $1,550, change, something like that. If you extrapolate the monthly sales to weekly sales, these percentages work out almost exactly. In other words, this is not like in bridge funding where the money that was being taken out had no relationship whatsoever to the actual receipts coming in. This seems pretty close. Am I right? At the
I would
contract, maybe they went down later, but when he signed it, this has a very close relationship to the percentage that's being taken out.
I agree with that, Judge. Yes.
So it was fair at the outset. Maybe the receipts went down as we went a few weeks in. And that's where it became onerous, I guess.
I believe that is accurate, Judge, based on my review as well. But I would like to make one other point on this reconciliation provision, and it's the fact that it's the whole idea of this agreement is that it fluctuates it's 15% of the weekly receivables. That is how the language is written. However, when you go to the reconciliation provision, it only allows a change once per month. So under the language of the agreement, it does not actually allow it to function, even if we're saying that there's no obligation of plaintiff to review the amounts weekly and adjust this on a weekly basis. If we're taking that position on that it's the burden of the merchant and in this case the defendants to on a regular basis adjust based on what's coming in. The agreement only allows them to actually change everything once per month. And also I've reviewed, dozens, if not 100 of these agreements. And in many cases, they have a provision in there that following the reconciliation, there's a repayment of amounts that are overpaid. So under this agreement, there's a hypothetical situation where our client overpays for the span of a month. And maybe for 1 week it was accurate, but for the remaining 3 it was inaccurate. And he has no way to recoup those losses that he got. And then he's stuck with whatever is assessed by the plaintiff for the next month after their review of the documents. And so functionally, this doesn't actually operate the way that it is supposed to. If it did, it should be titled that it's a 15% of the monthly receivables if that's what we're assessing, but it says weekly. I wanted to add that additional point on the reconciliation provision.
Does your client have any explanation for why he had 2 accounts with Bank of America when the agreement required him to only have 1?
I do not have an explanation for that, but I would be happy.
And that was at the outset. He maintained 2. This was before, I believe, any PayPal alleged fraud. He was supposed to have 1, and he had 2 from the get-go, right? Violation of the agreement right there.
That is my understanding, and if you would like a reason, Judge, I'd be happy to discuss with my client and provide additional briefing.
Well, just as a follow-up, it looked to me, again, going back to page 18, the portion of the agreement, it says seller shall deposit all future receipts into only one bank account. It seemed to me that you could have as many bank accounts as you want, as long as all the future receipts go into one. And I'm not sure which of these 2 is designated. I agree with Justice Lindley that there's 2 listed in the between pages 52 and 64 of the record. But so the one point though that you had made in the brief is that the fact that you have deposits into the account, that doesn't necessarily mean that those deposits are accounts receivable. Those deposits could be coming from a variety of sources. Is that right?
I think functionally that's an issue with a lot of these agreements where it says that it's for receivables. However, then when you read the definition of receivables is pretty much any income that's coming in. It doesn't matter if it's other loans. It doesn't matter. It's not necessarily accounts receivable, despite the fact that it is supposed to solely be based on the receivables. And to your point, Judge, the idea of the agreement and those the obligations that are there regarding the bank accounts is to ensure that there's no risk that there's receivables being hidden. So long as the receivables were being put into one account, to I believe the point that you're making, there's been no breach here because there's been no attempt by either defendant to prevent plaintiff from accessing what they're trying to access.
I guess we'd have to trace the funds to each account and see which ones, where they came from. One could come from some other business he had or some other source of funds. Another question that is unanswered here is your client says in his affidavit that he had to liquidate because of what the buyer did here, take money out of his account for a number of weeks, maybe 11 weeks at most. He had to sell $200,000 worth of firearms for approximately $92,000. Your client paid only $11,000 and only owed another, $25? What is the meaning of him getting $92,000 when he didn't even owe that kind of money to the buyer here, plaintiff? What's the purpose of that statement in there? Why did he get $92,000? And how's that relevant here?
I mean, he was the business was struggling to begin with. So it's a confluence of events that are happening. I mean, he was a struggling business in the first place, which is why he had to take a desperate measure and go enter an agreement that maybe he didn't feel 100% on. And then coupled with the judgment, or not the judgment, the lawsuit that later came is what prompted the additional financial issues.
I read his statement say the plaintiff's unauthorized withdrawals out of the bank account financially devastated Financial Arms. This $11,000 devastated them, and then he had to go liquidate all this stuff for 92. It doesn't seem to make any sense. I'm not hearing any more sense now. How about there's an allegation that your client had receipts of over, was it $500,000, $539,884 was collected between October 23rd and June 24th. Where did that funds come from, and is that true?
Well, that goes into the question that you were bringing up earlier, where we would have to trace the funds and see specifically where they were coming from. Are those receivables, or is that just any amount that's coming in? And I believe this argument was made in our brief as well, but the amount that was added together by plaintiff to come to that amount was not only define arms income or revenue. It was also amounts that were going into Mr. Favor's account personally, and the agreement is only for the merchant's receivables. So the additional amounts that our client was making are not relevant here.
You want to be heard briefly on the guarantee before we cede your time to the opponent?
Absolutely. I mean, I believe that most of what we've discussed most of what I have on the guarantee, but I think the important thing to point out is there's five specific obligations here. The one that plaintiff seemingly points to is the second obligation, and forgive me as I'm paraphrasing here, page 25 of the record. But the second obligation is not to take any action that would adversely affect the obligations under the agreement. Seemingly plaintiff's position is that what they believe was intentional blocking of the account was an act taken by our client to prevent that affected their ability to collect payment. And the issue here, as we've discussed with the PayPal account, is there was no volitional act here. Our client reported what he believed was fraud with someone trying to access his bank account. He brought this to the attention of his bank, and the bank took the action that they believed was correct and put a freeze on the account. And then ultimately that's the breach that's being claimed. There was no intentional volitional act that was done by our client to impede plaintiff's ability to collect payment. The bank saw fraud or believed there was fraud, and so
So there was no way your client could pay any of his bills once that fraud was put on there by the bank?
I'm sorry.
There's no way your client could have paid any of his bills through Bank of America once that fraud claim was made? That fraud.
I'm unsure what bills he was able to pay or not, personal or business wise. I could certainly ask him.
Seemed like the answer is quite simple: is don't pay anything to that PayPal account and pay my other bills. But in any event, we understand your argument and we thank you for it.
Good afternoon, and may it please the court. My name is David Pecan with Proskauer Rose. I am counsel for the plaintiff respondent EBF Funding LLC, which is also known as Everest. I'd like to address the usury argument first, since that was first raised, and I recognize Justice Nowak and Justice Del Conte wrote a concurring opinion in bridge funding. But I guess I should first address the presiding judge's point about Sampson, because I think it's very clear that this agreement clearly meets the test of Sampson. First and foremost, it has an enforceable reconciliation clause. As was pointed out, it's a shall. There's only 3 requirements. You have to have a writing, you have to include the most current monthly bank statement, and you need to send it to a specified email address. None of that happened. The record shows none of that happened.
There's no affirmative representation of that it didn't happen. It's just that it wasn't said. If it wasn't said, and it may not have been your client's burden on the front end to say, they didn't attempt to reconcile, although it might have been nice to say they've never attempted to reconcile. He then responds to this affidavit saying that, well, I sort of attempted, but doesn't include the writing, doesn't include the email, as we discussed. And then there might have been an opportunity for like a reply saying, no, we disagree. Or, he made attempts, but he did it by phone. He didn't comply with the provision. That would have been great too. We don't have that here. Well, why should we assume that he didn't? Maybe he did. It's just not in the record.
Well, he actually tried to explain what he did, and that he tried to call that a reconciliation. And what that was he tried to negotiate. He tried to leverage the fact that he wasn't paying. And one of the things that hasn't come out yet is my client did not rush to bring this lawsuit. My client waited over 3 months, but we had someone who wasn't willing to make the written request, but even more importantly, wasn't willing to give the monthly bank statement. As you can understand, my client needs to know that when someone says, well, these payments now exceed the specified percentage, we need some proof of it. That's what this agreement is set up to do. And so I submit to you, Your Honor, as your first question early on about, burden of proof, we, Everest, have met our burden of proof here. And it is really on, in this case, the defendant, appellant, to be able to come to this court and say, we sought a reconciliation by doing 1, 2, and 3. Instead, they said, we kind of sort of reconciliation because, after all, we tried to negotiate a lower amount. Otherwise, it would be imposing a burden on Everest that it shouldn't have, at least not under this agreement. So if I can, I was going through the Sampson provisions. I believe it's an enforceable reconciliation reconciliation clause. There is no fixed term. In fact, a fixed term is explicitly disavowed. And bankruptcy is not an event of default, or as was said in Sampson, there is limited recourse in bankruptcy. What we've said is defendants essentially argue, and we didn't hear it here, but in their papers, they argued that Everest had a duty from day one to reconcile. That's not correct. We only had a duty if the 3-step process was met, and that never happened. There's also been an argument that
was that too complicated for a non-lawyer to follow those directions?
I would say absolutely not, Your Honor. This is core basic contracts. We hold people to the agreements they sign, right? They're receiving monies from my client. They have to read and sign the contract, just like my client is going to be held responsible for every obligation that it has under the agreement.
Can I ask you this? There's a mention made of the Attorney General's lawsuit against other MCA companies, buyers. There's the Richmond case, and then there's Yellowstone. Massive damages, $1 billion in one. Have you looked at but not all MCA agreements are the same. Have you looked at the agreements there in those cases where they found to be onerous, unenforceable, and the one in this case? And if so, how does this differ from those that were found to be terribly improper in Richmond and Yellowstone?
Yeah, Richmond is one of those extreme cases with terribly bad facts on the part of the funder. But in Richmond, my recollection is the reconciliation clause actually did make it a requirement for the funder to provide a reconciliation. There was no obligation, as there is here in this agreement, to make submit a writing, to provide bank statements, and to send it to an
Were the
address.
numbers, here the numbers seem to bear, if the numbers in the contract are accurate, they bear a very reasonable relationship to the amount that's being withdrawn every week. Was that not the case in the Richmond and Yellowstone cases?
Well, Yellowstone is a very complicated case. It goes on for years, and there are a bunch of different contracts, as I understand it, that are at issue. It's not a single contract that's at issue in Yellowstone.
Yeah.
So it's hard to answer that question, Your Honor.
No, their argument on the other side, these are bad agreements. Look what happened in all those cases. Why shouldn't we reach the same result here? And I guess so I'm asking, why is your agreement different?
Well, it sort of goes to, I guess, the concurrence and the test there, which says, is there some reasonable relation between the weekly payment and the monthly sales and the yearly sales? And I think you address that yourself. When you do the math, it's right on target. But I think the concurring opinion in bridge funding focused on the fact that there were also round numbers that were used there. You look at this agreement on the record on page 17, there are not round numbers. There are very precise numbers to the penny of how much the monthly sales were, how much yearly sales.
That can be backdoor. You can reverse engineer that very easily. If you want to have 174% loan over 23 weeks, starting at $25,000 to pay back $36,250, the exact numbers that were used here, you could reverse engineer it and say, okay, well, if we want to say it's 15% and we want the payment to be this, then therefore we must say that your revenue is about $47,000. So then you could pick that number, or the merchant could pick the number and say, no, my revenue is $47,000, in which case then it's not reverse engineering. But it could go either way, right?
I don't dispute that, Your Honor. If someone wants to be nefarious, sure, they can back into whatever number they want. But here, first off, the contract states very explicitly that the merchant is representing and warranting, I think it's on page 17 of the record, but representing and warranting that all the information that's provided and reflected in the documents is true and accurate.
But he signed off on that monthly amount.
That's right.
This merchant signed off. Now, maybe he didn't read it. Maybe he was desperate for money and I'll just sign anything, but by signing this, he said my monthlies are 47.
That's right.
That's a little different than a bank just coming up with numbers and working backwards.
Absolutely. And that's why I want to address it. And there's nothing in the record, right, where you have the merchant saying those numbers are not correct.
Right. But every case of usury, every case where somebody is so desperate that they borrow at a ridiculous rate, they always sign off, right? They always sign off on that and say, yeah, this is it. I mean, that comes with the territory with this. That's why we look at that.
Well, Your Honor, yes, except even under the test that I think you laid out in your concurring opinion, this would meet it just because the numbers tie out. I know you say, well, you can back into it, but at the same time, you don't have the merchant disputing it. And I think you have to put those two things together rather than make an assumption that the numbers are fudged and the merchant doesn't read their agreement. In that case,
This merchant's only excuse here was PayPal somehow got set up and it put a hold on that. He never says these numbers are out of line with my actual sales. His was either you or another lender, somebody else, which might create a problem too, right? Had my email address and one of you set up my PayPal without my authorization. That's why I'm not paying. That's his whole defense.
that is correct. And he says the bank then put a fraud hold. But 3 months, Your Honor, over 3 months, we see monies coming into the account. The bank statements show that. Okay, so the facts show that there were future receipts. And we also know there were future receipts because I think it's on page 87, paragraph 7 of the record. The Mr. Favors made a representation that the reason, he came to us to try to negotiate a lower payment because his weekly receivables had gone down. So we wanted to get something, I think his words were, more in line with my weekly receivables. Well, by definition, he had future receipts. Otherwise, he wouldn't have to negotiate a lower number. If he had no receipts, then he wouldn't have to pay us anything. That's how.
I guess somebody could look at this on the other side to play devil's advocate, is that there's some questions here. Why not give the man his day in court and we'll get answers to all this stuff. What were the two bank accounts about? Why couldn't you get that hold lifted? What were your actual receivables? How did they compare to the amount taken out? We get some certainty on that, get some evidence. This is just on papers.
Well, I think, but on papers, as a matter of law, the court probably reached the issue that A, there wasn't any usury, and B, as a matter of law, we had established our claim under the contract. So otherwise, I think almost every case could go to trial.
That's what summary judgment's all about, I guess.
It is.
Last point on the guarantee, because we're running short on time.
Sure.
The Defiant Arms is out of business. So the only way you're getting paid is through that guarantee. Fair to say?
I believe it's out of business. I don't know that the record makes it clear whether it's out of business.
So the guarantee he didn't guarantee payment.
Correct.
He guaranteed the performance of those things under Section 5 of the agreement. In your motion, what did you rely upon? Where did he fail to perform? What was the allegation there that he failed to perform? What section there under the Section 5?
Well, he failed to perform under Section 2.1 by giving us prior notice that the funds would not be forthcoming.
Yeah, I don't see that in I'm talking about what you argue below. You argued a lot of things on appeal.
Yeah.
But below.
Below, I believe that was one of the things we may have argued.
I think the only one you argued was 5.1.2. You referenced it.
Yes, 5.1.2 is the guarantee performance, but the language of that guarantee of performance brings it back to all of the provisions in Section 2. And so what I think we did was we took the facts in the appellate brief and more closely aligned them with what 5.1.2 ties in. So for example, they failed to honor the continuing representation and warranty to maintain the account as open and active for our benefit because they allowed it to be inaccessible for months. They failed to hold the specified percentage in trust for Everest.
Again, I don't mean to interrupt, but I will.
Sure.
Because this is what you're arguing on appeal. Down below in your memorandum of law with respect to the guarantee, the only argument I see is you say here, merchant had prevented plaintiff from receiving the specified percentage of merchant's receivables, and by doing so, had breached the agreement and his performance of the agreement. See Section 5.1.2.
That is correct.
That's the only section. So the only section that's preserved.
But well, I submit to you, Your Honor, that factual assertion, though, ties into the various provisions that 5.1.2 in turn brings in. So for example, by making the account inaccessible, not having it open and active, and that's what that language touches upon, that is a basis, not for failure to pay, but for a breach And all we would need is one single provision. And I submit to you that one ties directly to the factual allegation we had there.
Thank you very much.
Thank you. Appreciate your time.
Case 37, matter of Niagara Metals LLC versus City of Buffalo Zoning Board.
Good afternoon, Your Honors. May it please the court. Lindsay Habenreich from Phillips Lytle, appearing on behalf of the petitioners appellants. So this case might appear to just be a mere hyper-technical argument or trivial error, as our colleagues have framed it up. But as a zoning attorney throughout New York State, I see this as an important land use issue that can carry significant implications for zoning boards throughout the state. So this really comes down to, at a December hearing, the zoning board made a motion. That motion was seconded. It went out for a vote, and no one else voted.
There were 3 days, 2 A's, and then they voted to table it. And your position is that was denial once 3 said nay. It seemed, correct me if I'm wrong, but the merits of this issue, whether a use variance is needed, is going to be addressed by this court in your subsequent appeal or here.
That's
or we remit it. That issue, because your client appealed from the December and the February orders. So this isn't, we're going to get to that issue. It seems like what's going on here, and I'm not saying it's nefarious or anything wrong with it. It might be a good strategy, but the reason you don't want us to address the substantive issue on whether a use variance is needed from the February appeal is because the record is better for you on this appeal. There's the evidence in the affidavit about remediation and why the prior why they couldn't operate this junkyard while the brownfield remediation was going on. All of this, why we're here today, seems to be you want us to decide that substantive issue with this much evidence rather than this much. Is that?
No,
I'm not saying there's anything wrong with that,
Sure.
but that's why we're here.
Yeah, no, I respectfully disagree. I think the records between the December hearing and the February hearing are largely the same. And at that December hearing, all of the parties were prepared to move forward at that time. There was no argument from Ames counsel saying we need to put in more information. And by this argument that additional information was needed and that we're trying to limit the record, that argument is made for the first time on appeal. It was not made before the trial court. And the information that they point to as being new information was not, in fact, new
We're gonna get
information.
to the merits of this issue.
Yeah.
Either from February appeal or this appeal. It's gonna be that issue. We gotta resolve it. Why are you going through all this time and expense on behalf of your clients? A lot of whom are citizens who live in this area.
Absolutely.
They're spending all their money and all their time just to prove some point that may come up later in some of the other cases down the road.
No, I think it's, we had to go out of our way to make sure that this issue is preserved so that we got to get to the decision on the merits. So hypothetically, what if we had not challenged this December hearing? It gets up on the merits and this court says, you know what? Final decision was made back in December. You were foreclosed.
Fair enough.
So we had to correct essentially the city's mistake.
Good. I'm not accusing anybody of any wrong. I was just curious of why we're going to do this. But all right, so your argument is that it was a denial because it didn't carry, the motion to table was too late and therefore it was over. And
That's correct. They never got a majority vote, so it was a failed motion in their meeting minutes.
Right, then we send it back and we need a determination from the trial judge on the merits here.
Absolutely.
This Tall Trees case you're talking about?
Yes.
It was codified later.
That's
right?
correct. In what's currently General City Law 81A.
With the 60, and basically the statute says if the zoning board doesn't make a determination within 62 days.
Correct.
It's deemed a denial.
Absolutely, which is what happened here.
Well, they say by the time we got to February, it wasn't 62 days yet.
Right.
So they still had time. So that statute didn't apply. That whole Tall Trees didn't apply because we didn't get to the 62 days.
Well, so it applies. It's what the city's position, what Ames' position is that February decision amended the December decision. But to give General City Law 81A any meaning, They had to use the word. We don't dispute that general city law gives them a mechanism to amend a motion or rehear a motion, but that never occurred here. A search of the record here, and this is where we believe the trial court erred, they found that that procedure was followed. But the zoning board never said the word amend or rehear or correct or modify.
If they had voted to table before, that was the only vote in December. Let's just table this because the situation was new information got submitted last minute, last day. Two of them were prepared to vote on it without even looking at it. Three said, nah, if they had just tabled it, then you have no argument.
That's correct. It would have been a final decision on the merits. That's correct.
Well, the motion that was brought was a motion to approve.
To approve, correct.
And that motion failed.
Correct.
So they didn't approve it.
Correct.
You're saying that under the city law, they then had to deny it. There is no opportunity to say, well, we didn't approve it today. We might approve it within 62 days. You're saying that doesn't exist. That's made up.
That's correct.
I see.
Yeah,
But
they had to get a majority vote. They never got it. It's a failed motion.
why didn't your client adhere to that?
Well,
Why did your client then go forward and agree with the city's representation on that and then submit additional documents and then show up at the February hearing and all that, continue it?
And in fact,
look at that course of action.
Our client made a motion to the zoning board to rehear the December decision. We made a motion saying, you made an error. I don't think you meant to do this, but you unintentionally denied this by having this motion on the table and not getting an affirmative vote or taking any action to withdraw it, amend it, remove it, do anything. So we made a motion to rehear. The zoning board ignored it. They just moved forward in February as though that December vote, that December decision motion had never been made. And I'll point this court to the same board with all the same parties in April of 2024. They had the exact same identical situation happened. A motion was made to to deny variances, Ames variances that it needed for the project. It was seconded, it was out for deliberations, for discussion, and a couple of the members similar said, hey, I think we need a little bit more time, so let's table it. The city corp counsel at that time, the same attorney who appeared in these matters before the Supreme Court, said, whoa, wait a minute, before we do this, we have to fix this. So someone make a motion to amend or withdraw or correct that. They did so, they corrected that motion and instead made a new motion to table. So if the city believes that it followed all of the proper procedures in December and February, why did it change its tactics in April? It's because it didn't comply with general city law.
Anything further you wish to add?
No, thank you, Your
very much,
Honor.
Counselor. We have Mr. Lee from the city. I believe he's going to be rather brief. Do you want to go? Who do we have on the calendar next? Mr. Lee is next from the city of Buffalo.
Good afternoon again, Your Honors. David Lee, Assistant Corporation Counsel for the respondent, City of Buffalo. The procedural history of the ZBA's proceedings are laid out in the city's brief, and it's clear that the ZBA made its determination to deny the appeal within that 62-day window. And therefore, the operative denial is the February 2024 denial. But I think more fundamentally, this appeal is moot because the ultimate relief that Niagara Metals seeks, which is appellate review of whether a use variance is needed for AIM to operate the scrapyard, is going to be before this court from the appeal on the ZBA's February 2024 determination.
Right. But based on a different record. The Forbes affidavit and all the evidence that wasn't submitted in December.
It would be a different record, Your Honor. That's true. And I think that's really what's going on here, as Your Honor pointed out.
Anything further you want to add?
No, Judge.
All right, thank you.
Your Honor, briefly, Jay Cohen for respondent AIM. There can only be one thing going on here, right? The only thing that be going on here is the attempt to come up on a different record, because there was no realistic view that there was ever going to be a missed appeal, right? The argument was, the motion was tabled. They went to the city. The city said, we have not had a final action. And the appeal under section 81A of town law runs from the entry of a decision by the board, entered by the ZBA. The ZBA never entered a decision. That's what C5
So
says.
you said there that the motion was tabled. Probably more accurate to say it was voted down.
We voted down and then
tabled.
tabled.
But regardless, to have a decision that from which you can appeal, you need to file it.
Correct,
And it was
unless
never-
you get to the end of the 62-day period and then there's a default denial.
Deemed denial there, but the filing
Was triggered.
never took place until after February. It was filed then.
Correct. Yes.
It couldn't have been an appeal here. The zoning board's vote means nothing without the filing, in your view.
Unless you get to the end of the 62-day period, right? And so this notion, just because it's in uppercase caps in petitioner's brief, an unintentional denial, that's a made-up term. It's not in the statute. There's a denial or there's a default denial in the 62 period. There was no unintentional denial. The board made clear. So now what we have is an effort to impose Robert's Rules of Order on the Buffalo ZBA and said, you made this mistake. You had to either table first or say, this is a motion to amend either in December or February. And Your Honor, it doesn't make any sense. The idea of judicial review of agency action is to have the benefit of the agency's full consideration. The agency said, we're not done. The reason why there's an expanded, I'm sorry, yes, Justice.
No, that's okay. I kind of wanted to hear the second point. I was going to hold off, but.
Okay.
Say the reason why.
The reason why the record is expanded is there were additional submissions by AIM in January. By Niagara in January. So Niagara wrote the board, submitted a timeline. There were responses. It expanded the record. Yes, it asked for a rehearing. It was expressly told there's nothing to rehear because a decision hasn't been made. And talk about bad policy. Bad policy would be to say that we're going to trip up these body of laymen who devote their time to the zoning boards on Robert's Rules of Order points. You made the motion to the table too soon. You didn't call your motion in February an amendment. We have to cut through that and look at the merits.
It appeared to be from reading the minutes of that December meeting that the nay votes were not nay on the merits of the appeal. It was nay, I'm not quite ready to go yet. I want to read this stuff. And that's a little.
Yes, Your Honor, that's what they said.
Different. I'm voting no, not because I'm not taking a view on whether this was a non-conforming use. I'm voting no because I wanted to learn more about these.
Because I got all this information this morning, and this is an unusual appeal fought with unusual vigor.
But they would say nay is nay. It doesn't matter why.
Yes, but there is nothing in the there's nothing in the statute that says that the board, prior to entering its decision, couldn't simply reconsider. So now the question is, do we ignore all that because the words motion to amend were not used? Or do we ignore all of that because the tabling motion was late? That's not set out in the statute. The statute clearly gives the board 62 days to decide. They timely decided we'll be here on the merits. There are actually two more. We're going to be here twice more because we've had a third petition, which has been decided against the petitioners, and there's a fourth one yet to be decided. But this is not the time that we should have been here at all.
Thank you, Counsel. Last case for argument is number 38, matter of John J. Mills versus Erie County Legislature, case number 38. Mr. Piggott is remote. We are waiting for him to be let in. Mr. Piggott, good afternoon. Thank you for your patience, and same to all of you. I know it's been a long morning, afternoon to get to this point. Mr. Piggott, you may proceed with your argument.
Thank you, Your Honor. Good afternoon, Your Honors. May it please the court. My name is David Piggott, and I represent the petitioner appellants Mills, Marchizewski, and Tronalone. In this case, it must be made clear that the only entity that can change the metes and bounds of county legislative districts is the county legislature itself. The Board of Elections can't do it. the Supreme Court can't do it. Arguably, in an emergency situation, you could have a court impose a temporary solution because the legislature refuses to act or can't act. But generally speaking, the legislature has to fix the legislature's own metes and bounds. If I wake up tomorrow, or John Mills,
Councilor, just to be clear, the legislature did adopt a local law that set the district boundaries, correct?
yes, Your Honor.
Right, and you're not challenging the local law.
No, Your Honor.
Right. So, I mean, that's one of the points I think the respondents are making here is to send this back to the legislature. That would be a second redistricting within the decade.
Perhaps. And I think that is an open question.
But that's not what you're asking for here, right?
No, it's not what we're asking for, Your Honor. What we're saying is that there is a law on the books. Local law number 2 was passed by the Erie County Legislature in accordance with the process prescribed by law. The consequence of that law was an amendment to the county charter. That county charter was and is on file with the Secretary of State's office, defining the metes and bounds for the legislative districts within Erie County. That is the singular authority. It doesn't matter what's on the county elections website. It doesn't matter.
Right. So I understand that part of it, but when they adopted the local law, or well, let's put it this way, when it was before the legislature, they had what everyone has referred to as the desk maps. No one disagrees that the desk maps were in front of those legislators who were going to vote on the local law.
I think the record's clear that they were there, Your Honor. Yes.
Right.
And the desk maps are not consistent with the metes and bounds.
That's right, Your Honor. The desk
So,
maps.
with respect to the remedy, you want to enforce local law number 2 of 2022, even though it's inconsistent with the desk maps. You're not challenging the validity. You just want to enforce it as written, even though it was mistakenly written.
That's right. I think, I think, we want fair, honest districts, right? But what we've got is local law number 2, and local law number 2.
Doesn't local law number 2, can it be enforced as, aren't some of the districts extend well beyond Erie County and up into the Antarctica even? What's the Board of Elections to do with that?
No, I think that's right, Your Honor. I think penguins in Antarctica could reasonably stand for election in Erie County under the current law. It's undisputed that the law is in need of correction.
Let me stick with Justice Lindley's question here for a minute. We had the 2023 primary election, and then this lawsuit came afterwards. And as I understand it, part of the relief you requested was for the Board of Elections to almost recanvass those votes as you would have interpreted them under the local law, as opposed to the maps that the Board of Elections utilized. That's one of the relief, that's one portion of the relief that you're requesting. Am I right on that?
You are, Your Honor. That is part of the relief request.
Right. So as far as that relief goes, then the Board of Elections was supposed to do what? Assign people to districts that were in Antarctica and didn't really exist?
Yeah, I think it's a very good question, Your Honor. And realistically speaking, I don't think we're asking this court to go back and invalidate the results of the 2023 election.
But that's what you asked. I think that's the issue here. That's what you asked the court to do when you said the court made a mistake by granting summary judgment by declaring that the second set of maps should be used in the election. You wanted the court to go back and assign voters to other districts based on the impossible to implement statute. Is that right?
That's right, Your Honor. That is the relief request. That's part of the relief request.
That's what you're asking us to do, is send this back to the judge so that the court can then assign people to impossible districts.
I think that if you list out the negative consequences from the legislature's failure to prescribe reasonable districts, that is on the list. I think the reality of time marching forward and these processes taking longer than it takes for elections to happen means that we probably can't go back to 2023 and make corrections to that
Right.
election cycle.
It sounds like realistically, you want the remedy to be prospective. It's not
That's
realistic to go back in time, even at the time you wanted to, but we're looking going forward. So on the legal issues presented, do you take issue with the finding that the maps control over the language, the meets and bounds language, if there's a conflict?
Absolutely, Your Honor.
What's that?
Absolutely, Your Honor.
Yeah,
The
do you wish to be
language
heard on that?
controls
Okay.
the-
And if the maps had been transmitted to the secretaries down to Albany, would that make it different?
It would not make a difference, Your Honor. The language would still control, and that's because that's what the enabling statute, the enabling law prescribes, language over maps. And I get it, we love maps, right? It's nice to see a pretty picture with lines on it, but maps are inherently inaccurate, and that's why in this and in other contexts, such as property law, we rely on legal descriptions. And then people can draw maps from there if they want a nice, pretty picture of what the words mean. But we have to have an absolute default standard. And the absolute default standard for election districts in Erie County is what's in the county charter filed with the Secretary of State's office. And that still has the language from local law number 2. Doesn't matter what's on the County Election Commission's website. That's just their interpretation of what the law says. If John Mills wants to run for office tomorrow and he's got to go figure out what district he's in, he's going to go to the county charter. He's going to go to the official county charter certified and filed with the Secretary of State. And he's going to read the exact words that are in local law number 2. He's not going to go anywhere else. There's nowhere that says, well, these are suggestive. To find the real lines, you have to go see what Commissioner Zellner said on the Election Commission's website, right? That we don't do that. We don't say that the content of a website trumps the official authority on file with the Secretary of State's office, and that's still there at this very moment, and that's what governs this case.
Do you wish to be heard further?
That felt pretty good, Your Honor. I was going to pick on New Jersey and say they have terrible football teams, so we can't follow their precedent, but I think I'll quit here.
Well, we do see the Bills helmets in your background there, even though you're out in Colorado, but we'll overlook that. Thank you for your argument. We will now proceed to Mr. Shad.
Good afternoon, Your Honor. Thank you for taking the time at this late hour to hear us. As you know, I represent interveners who sought relief in intervening to ask the court below to determine that the maps that the Board of Elections implemented for the June 2023 primary should be considered the maps going forward as the proper implementation of local law number 2 for the following decade. That relief was granted. I want to try to point to 3 things in the fundamental arguments that we see in the appellant's brief. One is that this argument that the court cannot consider intent, and that the court can only deal with this problem of the poorly written meets and bounds through legislative change. The reality is the simplest steps are legislators pass bills that become law. Courts interpret them with the plain language, unless, as in this case, the language is impossible to implement as written, in which case the court must then implement or interpret the law in order to have a proper implementation. But the third step is, what's the role of a board of elections? Remember, the board was the defendant in the initial litigation. The county was later added, the county legislature. The board's duty is to implement the law. It isn't to implement the law that everybody agrees is crystal clear. The rule is you implement the law, and I've cited a number of sections in Article 4 about very particular parts of the scheme intended to burden the boards of election to take actions to guarantee that primaries occur and occur on time. And then there are the penalty provisions, again, which I cite, that no one may take action or fail to take action that would frustrate a primary, and a commissioner may not take action
that would violate his duty. But what's the commissioner's duty? What are both commissioners' duties? Their duties are to implement the law as best they can. And trial counsel below, in a quip to the court during the trial, said, well, this is a train wreck. Do you expect the Board of Elections to implement a train wreck? Well, I think regrettably, however you would look at it, if you're a commissioner, that's your obligation to do your best to implement it. In this case, was a hearing to determine whether or not this law could be implemented consistent or was implemented consistent with the desk maps. And the court properly concluded, I think, on the evidence that it was. And so a set of maps more defined that could be posted on a website and meets and boundaries that were clearly defined resulted in the 2023 election. Are
you assuming that the legislators, when they voted for local law number 2, they had the maps in mind or the meets and bounds in mind? You're assuming that because they were in conflict. So you're saying their vote was, I vote on these maps. I like the districts in these maps. And they didn't look at the meets and bounds, or they didn't realize it was different.
I don't think there's, right. I don't think there was any doubt they thought they were enacting the maps. Now, they were small, and frankly, as I pointed out in the brief on the recitation of the facts, they're not as well defined as a large map with clear lines to where you can identify each individual election district. But there's no doubt that they thought they were adopting the law that matched the maps and the meets and bounds. The Board of Elections, in implementing that, and there's lots of testimony of variances in how they did it, did so in a manner I think that is consistent with the intent of the legislature to reapportion Erie County's legislature. There's no dispute about that. There was never a claim that anything in the numbers of people in any district was somehow violative.
Council, if I could, I think there's a two-step issue here. First step is, were the maps to be incorporated in the local law? Did everyone who voted understand that the desk maps were to be read into the law, so to speak?
Yes.
The second issue is, did the Board of Elections, when they did their work, comport their work as closely as humanly possible? I think that's my words, to those desk maps. Because I think that's the second contention here, is that even if you're to attempt to comport the maps, we've got some variations and changes that otherwise move about 5,000 voters into districts that they should not have been in under the desk maps.
I'm not sure that that's the conclusion I would make. One would make that argument based upon the descriptions in the text as opposed to the desk maps. And there was collateral reference by Commissioner Moore about population counts. The reality, though, going to your first point, it's Heather v. Cray, the case that was affirmed by this court out of Niagara County that dealt with the issue of what a part of the record at the legislative body did not make it to the state Department of State. That's what happened in the Heath v. Cray case. That's what happened here. The court there held, and you affirmed, that the legislative record included the maps. So it was quite appropriate for the trial court, when examining the issue, to conclude that you resolve it by determining whether or not the ultimate product from the Board of Elections actions to run the 2023 primary, was it consistent with the desk maps? And again, I cited the cases, but I think the trial court's entitled to deference there. There was testimony, but even Commissioner Moore conceded the fundamental argument raised by petitioners about unilateral action that said, yes, he worked with Commissioner Zellner to get this job done. They did a good job, and I think
what did you follow in 2025? What was the maps, or what was
the same maps?
So we 2023 and then 2025.
2025.
Now you're back to 2026 again, right?
Correct. And remember, this was a bill unanimously adopted. There was no dissent on the adoption of this bill. Thank you.
Thank you. Mr. Buckley.
May it please the court, Craig Buckeye from Phillips Lytle LLP on behalf of Commissioner Zellner, former Commissioner Zellner, and also we're joining in the representation of the Erie County Legislature for the purpose of this argument. I'd like to begin squarely with Justice Del Conte's question about the two-step analysis that needs to take place in this case. And I think Justice Del Conte hit the nail on the head. So first of all, it needs to be determined, should the district lines for Erie County Legislature be viewed through the lens of the so-called desk maps? Were they before the legislators when they voted? Did they intend to adopt districts consistent with those maps? And unquestionably, the answer to that question is yes. And the answer to that question can be found in pages 533 through 545 of the record. A majority of the legislators who voted offered affidavits to the court in which they said they intended, because they're not cartographers, they can't read metes and bounds with all of these references to north and south and east and west and latitude, longitude, and the like. So as lay people, what were they relying upon? They all said, that majority, that they were reliant upon the desk maps. And I go to the case CSEA versus Oneida County from the 4th Department 1980 that talks about reliance upon post-enactment statements of legislators in terms of informing what the statute means. And those kinds of statements can be relied upon in extraordinary circumstances. And I would say this is an extraordinary circumstance because we're not just talking about one legislator out of a 150-member state assembly. We're talking about a majority of the legislators who actually voted on the bill said they were relying upon the desk maps. And there's no dispute. Mr. Pigott just acknowledged this in his own argument. The desk maps were part of the legislative record. They were in fact clocked in, so to speak, at the Erie County Legislature when those were provided by the Advisory Committee on Reapportionment. So they were absolutely in front of all the legislators, and that is demonstrated at pages 469 through 490 of the record, the attachment to the affidavit from the clerk of the legislature.
We heard some discussion about the size of these maps, and it might be have been too small to really discern where the districts begin and end. And we had the Village of Hamburg. Were those discernible from a view of those maps that were in front of them?
Well, the argument is made that, well, the maps that were provided were not of a proper resolution, so to speak, in order to determine where precise boundaries were. And we would submit that, look, no demographic data was provided by the Advisory Committee. No maps of a zoomed in enhanced resolution were provided. What was in front of the legislators? The desk maps. And so it would be inappropriate to go outside the legislative record to look at maps that would consist of some kind of enhancement, because what's in the record? The desk maps. And when you compare the desk maps, this is the second part of the inquiry that Justice Del Conte had. When you compare the desk maps to the maps that were actually implemented by the Erie County Board of Elections, and we had a 4-day trial in May 2024 concerning this issue, the court can look at pages 1853 to 1863 of the record, because we did an exercise during the trial of overlaying, by way of transparencies, the desk maps for the county and per district on top of the Board of Elections maps for the county and per district. And there were no discernible differences, as Justice Martocci found, and as one can tell from the pages in the record, except with respect to a small portion of the boundary between districts 9 and 11.
25 voters.
Approximately 25 voters, because in the desk maps, the boundary was along Pleasant Avenue in the town of Hamburg. But the problem with doing that is that because under election law section 4-100, election district lines cannot cross a village boundary, that by having the boundary along Pleasant Avenue doesn't go along the southern boundary of the village of Hamburg. And so as a consequence, 3 more election districts needed to be created just for those 25 people, and all kinds of extra administrative difficulties, costs, having more inspectors would have been incurred if that were to be done. And so Commissioner Moore and Michael Agostino from the Democratic side of the board, we had testimony, they got together, and in fact, it was Commissioner Moore who suggested, why not have the line along that jagged edge
of the southern boundary of the village of Hamburg. And in fact, Mr. Agostino reached out to the legislature. We had testimony at page 1161 of the record, whereby it was confirmed, yes, that is what we meant to do. We thought Pleasant Avenue approximated the southern boundary, and it turned out it didn't. And so that is the one discrepancy. And so at most, if this court were not to affirm, we would submit that at most what this court should do is simply say, look, notwithstanding the administrative difficulties, those approximately 25 voters who live between the southern border of Village of Hamburg and Pleasant Avenue should be reassigned to District 9 rather than to District 11. And that gets me to the final point, which is that we submit the court can do that, and we would be fine with that. But we would submit also the Fourth Department doesn't need to do that. And the reason for that is I go to what Mr. Pickett said at the start of his argument. He said that the only entity that can change the boundaries of the legislature districts is the legislature itself. We would submit that as a patently wrong statement of law, because if that were true, then we would not have had the Harkenrider v. Hochul case that I argued before this court in April 2022 and at the Court of Appeals the following week, in which the Court of Appeals held that the congressional boundaries throughout the entire state of New York were to be so ordered by Steuben County Supreme Court pursuant to consultation with a special master. And in fact, the petitioners and Commissioner Moore, that wasn't their position before the trial court, because this court should look to page 133 of the record, whereby the petitioners themselves, who Mr. Pickett represents, asked for the court to fix the boundaries of the districts. And it doesn't comport with page 209 of the record, wherein Commissioner Moore asks that the court either engage a special master or redraw the lines itself. And you know what? That's exactly what Justice Martocci did, and she was well within her prerogative to do that, not only as per the Harkenrider decision, but also a whole host of appellate division authorities, starting with the Harradine case that we cited in point 5 of our brief from the Fourth Department in 1979. When there are errors in a real estate description, when there are errors in meets and bounds descriptions with respect to districts, the court can reform those errors by looking to the intent of the legislature and simply making a fix. And that's what Justice Martocci did, and she did so properly.
Could the ledge have even done it here, given the fact that they're limited to redistricting once every 10 years?
My response to that, Justice Lindley, would be the legislature was darned if it did and darned if it didn't. Because if it had, then Commissioner Moore would be perhaps here saying, well, that's a violation of Municipal Home Rule Law, Section 10(1)(2)(a)(13)(f) that prohibits mid-decade redistricting. And so the legislature didn't do it. The legislature didn't fall into that trap. And so now there's a pivot to the other argument, well, the court wasn't able to do it. I would say that that Municipal Home Rule Law provision, by its own language, says that changes to local laws in terms of mid-decade redistricting are prohibited. And what the court did here was a judicial order. It was not the enactment of a local law. It was well within the court's authority to do that. Now, the thing is, Commissioner Moore and the petitioners, they don't like the fix, because as Commissioner Moore testified at page 950 of the record, he said that these corrected meets and bounds create districts that are bad for Republicans, and he's a Republican commissioner. He respectfully disagrees with the result. He probably would have preferred that there be a special master who would have done violence to the map and have all kinds of new districts contorted in all kinds of different ways. But the fact is, he asked the judge, Justice Martocci, to impose a fix, and that's exactly what she did, and her discretion and that exercise of it should be upheld here.
Thank you. Ms. Friedman, you have the last word.
Okay. Thank you for your forbearance, Your Honors, at this very, very late hour. Excuse me, may it please the court, Catherine Friedman representing respondent Ralph Moore. I just want to hit a few highlights and respond to some of the contentions of the other respondents. As you know, respondent Moore totally supports appellant's position in this case. With regard to the questions regarding relief, I think we would ask the court to, this is included in the brief, to enjoin any further elections from taking place until the corrections are made
By
through
legislature,
through the legal process. Yes, Your Honor.
the court.
No, by the legislature. Uh, we seem to be respondent Moore and appellants are talking past the other respondents. We're relying on two totally separate, different bodies of law. It is our contention that the only entity that can fix this, because this was reapportionment, not, changing electoral districts, but the only entity that can conduct a reapportionment is the Erie County Legislature.
Isn't there a home rule problem under the home rule law doing it more than once every decade?
Well, Your Honors, I submit that this could have been handled quicker,
Counsel, I don't see in the briefs any challenge to the local law itself. No one claims the local law is invalid. It's a validly enacted local law. And you're saying the only fix to that is to go back and do it again. Or your position is to make substantive amendments to that local law.
Correct.
And a substantive amendment, wouldn't that be a second redistricting?
We don't believe so, Your Honor. Again, we think that it is.
But again, you're not, just to be clear, you're not asking us to determine that it was a nullity or is invalid.
Correct.
That it didn't happen.
Correct. Yeah, no, and we think that fixing it is really important. Respectfully, it's more than 25 people. It's 5,000, up to 5,000 roughly voters are affected. There were a number of, Commissioner Moore testified to a number of district errors. I believe it was page 918 of the record.
This goes back to my question. Your position, my question earlier, your position is that people ended up voting because they voted in the maps that the Board of Elections published. They voted in the wrong district.
Correct.
And they voted for the wrong people.
Correct.
And the court or somebody now or in the future elections has got to move voters around to put them in the right district. That's the position.
Yes, that's correct.
Rewrite the statute, rewrite the law.
And set it straight. It needs to be set straight. The reapportionment process that took place cannot continue to stand on the books. I mean,
That's to go back in time for the 2023 election, 2025 election and count votes as if under different lines, right? You're just looking forward.
That's correct. That's correct, Your Honor.
Because seemed to be a request in the pleadings to do that.
That's correct, but we're moving forward. We're moving forward on this. Let's see. I suppose unless you have any other questions.
No, your brief was very thorough and
Okay.
we appreciate your arguments and your patience.
Oh, thank you. Thank you.